Who's missing to the left of you? Oh, he's here. Okay. If everybody. This program is part of the college's commitment to give back to its the certain circuits, the respective communities. Here in Chicago in the 7th Circuit, I don't even know the number of years the college has put on this program. We put it on for everybody. In addition, and less known, and I'm throwing it out for the academics, is the college also works with the American Bankruptcy Institute in the late winter or spring with regard to the feeder program for the Duberstein moot court competition. And I know I'm looking at the professors over there shaking their heads. They know they've sent teams there, but the college also supports that program. And this program allows us to do that as well. One other thing, I'm going to thank the sponsors individually this year because part of getting ready for this program was dealing with the unexpected. And the unexpected happened to come in hard on costs. So if it hadn't been for our sponsors stepping up this year, this would be a very hard program to put on. So our sponsors are scrolling above my head where PowerPoints will come up shortly, but a really big thank you to Accordion, Edelman Gettleman, Advocate Capital Advisors, AlixPartners, the Chicago Kent College of Law for generously giving us this space in their Wi-Fi, Cozen O'Connor, Phagra Drinker, Fox Swibel, Godfrey and Kohn, Goldberg Kohn, Greenberg Traurig, Jenner Block, Kirkland and Ellis, Latham and Watkins, Malik Remian, Mason, Pollock and Schmal, Perkins Cooey, Ruben Levin, Steinhilber, and Swanson. Thank you to all of you. And then my final, So we think, but everybody's clapping online really loudly. But my final thank you is to Debbie Caruso, who has, without question, said yes to helping me do this year. And also without question is agreeing to take the laboring oar next year. Yeah. She's kidding. But anyway, she's going to come up and say a few words. Debbie is the co-chair of this program from Indianapolis, from Ruben Levin. And I couldn't have put this together, and we wouldn't be eating or drinking at 5:30 today without her assistance. So thanks, Debbie.
So I couldn't get out of that, huh? You did it in front of the whole room of people. So Yeah, thank you. So anyhow, for the past year, we've had the honor to work with some incredibly committed people on the Seventh Circuit Education Committee to organize and put on this event today. And our committee worked diligently to research and read cases and pick topics that we thought would be particularly relevant and also interesting. And it wasn't easy. It wasn't like we had a plethora of bankruptcy decisions coming down last year, but I think we picked some very interesting topics. We have a group of excellent speakers who have graciously agreed to volunteer their time and share their knowledge and their skills and expertise with us today. And we thank all of our speakers because it's a lot of work, as we all know, to prepare for and present topics in any seminar. So thank you very much. I would also like to acknowledge and thank the members on the Education Committee, Nancy Peterman, the Honorable Catherin Furay, Pat Nash, Jay Jaffe, Rick Bendix, Rick Mason, Dan Zazoff, Felicia Perlman, and Tim Nixon. So thanks to all of you guys. You worked really hard. We appreciate it. And on a personal note, I have to thank my co-chair. Actually, I was his co-chair. And Brian taught me a lot. Probably, there's a bit of fear in this right now too, going forward without him. He's moving on to do his job as a regent, but I'm not going to let him abandon me. Okay, so I'm calling you out too. Okay, so and if you do, I'll be stalking you all next year. Okay, because he worked so hard, and it was fun working with you, Brian. So thanks. With that, I'm going to turn it over to Vince Lazar to discuss the foundation. Oh wait, I forgot something. One thing I need. You're probably going to tell me about this. So throughout the session for the people on Zoom, there will be a code that will be read for each of the sessions.
A code and a poll. A poll, P-O-L-L, will also be launched.
Code and a poll.
Copy down the code, answer the poll.
Okay, so for the people on Zoom, you need to copy down the code for your CLE and you need to answer the poll. And then also, the consumer link that will be sent is separate from the main link because we do have a breakout session for the consumer folks. And we will let you know what room that's going to be as we get closer to that. Coffee, tea, and water will be served at our break, and that's coming. The first break is 3:15, so that should be out in the lobby. And then afterwards, we're having a reception that will feature beer and wine and hors d'oeuvres. So we hope that you will all stay around for the reception. Thanks.
So this year I'm vice chair of the American College of Bankruptcy Foundation, which is, and most of you know, is the charitable arm of the college. So I'm here today to encourage all of you to consider making a donation to the foundation. And for those of you in the college, I'm happy to report that we've got a new arm twister in the Seventh Circuit. So this fall, you'll be hearing from Pat Nash instead of me. So I'm very happy to get out of that role. The foundation's operation is straightforward. Really? Okay. The foundation's operation is straightforward. The foundation gives grants to community organizations that supply bankruptcy and insolvency related services to those in need. And it's the largest provider of these kinds of grants in the country. Donations that you make to the foundation don't go to the college. They don't go to support educational programming like this. Instead, 100% of all donations get redistributed in the form of grants to recipients that have been vetted by a volunteer group of bankruptcy judges and restructuring professionals. Many community organizations that provide safety net bankruptcy services operate on shoestring budgets and rely on grants such as those provided by the foundation for their basic operations. This year, we're also expanding the mission to include support for diversity, equity, and inclusion programs specific to the insolvency community. If you go to the college's website, you can find a nice long list of the dozens of organizations that the foundation supports and provides grants to. So making a donation to the foundation is easy. Go to the college's website, www.americancollegeofbankruptcy, one long word.com, and you'll find a link there if you want to make a donation. We are fortunate to be in a profession where most of us were able to work remotely and prosper for the last 2 years. And we're all hoping in the next few months, it's going to be even better for us. But between inflation and increasing interest rates and job
indebtedness of 7.5 million. We'll talk at length about what that means.
Does the code really define a debtor in a sub 5 as a small business debtor? Or does
Yes.
it simply talk about a debtor with debt limits?
No, the qualification is that you must qualify as a small business debtor initially. That's under, I have this
That's all right.
in the materials, but it's required. And then, as part of the 10151D qualification, the debtor must be engaged in a commercial or business activity. And the disqualification is that single asset real estate cases are prohibited from being both a small business case as well as a sub 5 case. So each of these presents some interesting issues. We'll talk about SAR at the end. Randy's got some interesting comments on SAR, but the first one, let's talk about engaged in a business activity, because that's probably the least interesting of all of it. And so if a debtor is not in business And that doesn't mean in business currently, it means was in business at some point and created debt that's related to the business.
Is that what the statute says? Or does it just say engaged in? So I think there's case law now on whether it's maybe you were in business or maybe your business purpose was dealing with your debts that you incurred
Correct.
while you were running a business.
While you were
The
running a
Statute just says engaged in.
That's all it says. So it's always the cases at the margin that are the problem, but that's one of the more interesting issues. Are you engaged in business now or were you, and does that qualify? Right? So
Well, and
that's,
what does it mean to be engaged in business? If the debtor operated a business, the business is closed down, but now they're winding it down and disposing of things. Is that still being
that's what
engaged in
that's what
business?
Randy was
That still counts.
referring
I've
to.
come across at least 2 cases where I've been the trustee where it's a personal debtor that has accumulated debt from a business that has closed down. And now they are filing to seek some sort of relief from this debt. In the margin. I feel like subchapter 5 is always in the margin.
So let's talk about the debt limit. Little history, you probably are familiar with it. The debt limit currently is 7.5 million. That is a compromise, as most things are from Congress. It is set to, it's subject to a sunset on June the 24th of 2024, when it would revert to approximately 2.7 million, give or take of inflation adjustments. But for now, it's 7.5 million. I suspect it'll either remain at 7.5 million or go up to 10 as the original authors intended, but that's for future reference. Right now, it's 7.5 million. The 7.5 million debt limit, however, includes debts that are owed both by the debtor and affiliates of the debtor. So if you and so the first initial issue you have to look at is if this debtor is affiliated with other debtors, is there a requirement of aggregation of the debt? And if the aggregation is in excess of 7.5 million, does that disqualify the particular debtor? Does it matter whether those affiliates are filed or not filed in order to meet that 7.5 million exception?
Jim, I'm gonna focus on the statute again in terms of the grammar talks about, the affiliated debtor test is at the time of filing. And so there's lots of cases out there where there's multiple LLCs that are under common ownership, and the courts are going to aggregate those debts for purposes of the test that Jim was just talking about. But what is to stop the debtor, who's the common owner of those multiple LLCs, from moving ownership to a relative to no longer be, or not a non-relative, a friend, to no longer be an affiliate?
I don't think there's anything to stop it other than if they get caught by the
Good
creditors,
faith,
who
right?
might claim a fraudulent transfer or something of that sort. But at the time of the filing, if there are no affiliates, I think it then is the duty of the trustee and the creditors to inquire further about whether there were affiliates at some point.
So we'll put that under the pre-bankruptcy planning for the
Yes.
debtors council to
Exactly.
figure out how to stay under the limit.
How to stay under the limit, that's right. And then the question is, when do you count the debt? This is the InfoWars Alex Jones problem, where his initial filing, he knew he had a multi-million-dollar judgment that was going to come down, but it was unliquidated at the time. And the 7.5 million does not include unliquidated claims. So as a result, he filed for
Alex Jones.
he filed for sub 5 qualification because his other liquidated claims did not add up to 7.5. And
So this is mischief, right? I thought it was fascinating that it was the U.S. trustee that objected to the qualification. The statute on its face doesn't include contingent debt. So what's the basis for objecting? But you can see obvious opportunities whenever an individual is getting sued. It could be a tort litigation, it could be contract litigation, it could be anything that's gonna put them over the $7.5 million number, if they're on the verge of losing. And so the pre-bankruptcy planning is, well, it could be a $25 million judgment, and then they clearly wouldn't be eligible, not within the purpose of Subchapter 5. So is it appropriate to file before that judgment comes down, or is it abusive?
Or do you have the forethought to say, maybe I shouldn't do subchapter 5. If I'm going to file, I should just file a regular 11.
But there are so many benefits to sub five that, and that we'll get into when we get into the discharge portion. There's so many benefits to it that, there is planning that would need to be done. Now, Alex Jones has filed another case. The first case, it was cited in your materials, was voluntarily dismissed in the face of the U.S. trustee bringing the motion to disqualify InfoW, I think is the name of the company, from
But what's,
filing.
what's the ultimate, I'm just from a creditor's perspective, I want this tool. What is the statutory hook? Is it when there's you just object to proceeding in Subchapter 5 on the basis that the debtor's not eligible because, what's the argument?
Yeah, what is the argument? Because it does quote on the date of filing, end quote, mean what it says. And on the date of filing, in his case, he had a very large but unliquidated judgment that was going to
Well,
flow in.
and contingent.
Well, I don't remember now whether the judgment was entered, but the damages hadn't been determined yet or what. But, so it may not have been contingent, but it certainly was unliquidated.
So is it a good faith filing?
I think
Objection?
good faith is probably where you have put your hook.
So,
Yeah.
I mean, most of us know, right, because we try to do this in other Chapter 11 contexts, it's hard to knock out filing that's, you allege not to have been made in good faith when there's no requirement for filing in good faith. So, how do you, are they in a box? And what is the, argument ultimately that's going to persuade a judge to not allow them to proceed in Subchapter 5 based on good faith at the time of filing?
Well, it could be, and of course, I'm more than willing to give advisory opinions that I am also absolutely willing to change my mind if the question ever comes up, but it's sort of like pulling forward. I mean, if a condition of confirmation of a Chapter 11 plan is an element being good faith, if you can't confirm a plan because the plan's not proposed in good faith, how do you, can you propose a plan in good faith if your entire bankruptcy was not filed in good faith? I'm not certain what the answer is or how I would rule on it, but that might be a way to sort of pull the question forward.
From a planning perspective for the debtor's lawyer, however, in terms of eligibility, this question of timing of the filing and whether or not affiliates exist that would create an excess of debt are two items that you'll want to use for planning purposes and that the creditors will be keeping a very close eye on, as you can hear. The next one that's interesting though is there a way to get around the disqualification of the SAR of cases if a debtor is a single asset real estate debtor defined as such? Is there a way to get around that? And it seems to me, and I've seen this being done, again, the question of good faith arises, is whether someone who owns a series of LLCs that each own a single real estate enterprise could simply dissolve the LLCs, and assuming they fit under the debt limit, could dissolve the LLCs and put them all under their own name and file under sub 5, because at that point, they're not a single asset real estate debtor, they're a multiple real estate asset debtor. And I have actually seen this done as part of pre-bankruptcy planning. And again, I'll turn to Randy. I, as a debtor's lawyer, kind of find that to be problematic, but
Has it been challenged? Have you seen it?
but it's never been challenged, so that's the problem. It's never been challenged, so we don't know which way.
What about operating, the single asset real estate and then having the, ancillary, work that's being done, assumed by the debtor? You have this in the materials with the, Palace Theater case, and, just looking at that, I think a natural reaction is, well, what if they just merged the single asset real estate debtor into a non-single asset real estate debtor? You've got the aggregate debt test, so, what's wrong with that? I thought it was a curious ruling by the court it's good for creditors to, where the court said, look, they really are still a single asset real estate case, but if you have a valid merger that's not done fraudulently, it's being done so the debtor can take advantage of the federal statutes. Don't quote me on any of this. What's really wrong with that?
We didn't think anything was wrong with it until Judge Blyce told us we were wrong, so. But you do raise a very good issue, and one that practitioners who operate in this area will run into a lot. A traditional setup for most businesses, closely held, is that a LLC will own the real estate, and the corporation that actually operates the business will own the business and then rent from its own LLC. Effectively, we've all seen this setup. It's a tax setup primarily. And it seems to me that the merger of those two, or put differently, the transfer of the real estate asset from the LLC into the operating company or corporation. So long as you do it recognizing that there could very well be due on sale clauses or other things that might prohibit that kind of transfer. That may be one way of resolving this problem, where you have a true transfer of the property into an operating company, and now you don't have a single asset real estate case any longer, but I don't know.
Yeah, I mean, in the mid-90s, it was like, that was the thing to do. You created a new debtor. I think called it the new debtor syndrome. You would move the asset away from the other complications or things that the owner didn't want to have affected by the Chapter 11, and just transfer it to a new entity legally under state law, and then file. And a whole jurisprudence grew up around that, whether that was a bad faith filing. So I think you're going to see some of those doctrines and arguments come back in the context of whether what's being done is legitimate pre-bankruptcy planning to take advantage of a federal statute, or crosses over into a bad faith filing. But one other thing to think about, the real estate lawyers at the time that were horrified that their projects could be subject to Chapter 11 developed the bad boy guarantee. So I think most of us know what those are. The individual who owns the property is not a guarantor so long as they don't do anything bad. And the bad things are defined as, among other things, putting the project into bankruptcy. So in this situation, assuming you meet the aggregate debt test, think about the nightmare now for the lenders who thought they had this all packaged up pretty well, that they had this bad boy guarantee. Well, that bad boy guarantee is going to be a general unsecured claim that is now going to get treated under that Subchapter V over 3 to 5 years. It's not going to be an effective blocker, I don't think, in a lot of cases. So it's sort of back to the drawing board on some of this stuff.
I was going to say, I'm lamenting not at all for this poor creditor's lawyer over here. They're so creative. They'll find ways of getting around it, so.
I had a case that was a car wash, so it was two entities. There was a SAR and then the operating entity. They both filed. The SAR filed for a regular 11, and then the operating entity filed for sub 5. Together, they were under the debt limit, so it was jointly administered. They filed one plan, which, clearly was subject to the sale of the real estate to pay off the creditors. It went through confirmation, And now creditors in both cases are just waiting for this pending sale. I'm still holding my breath for my fees, but, as are all the other creditors. So I don't know that there's a right way to do it, whether you merge them before and file, whether you file them separately. I think, either way, you're still kind of waiting in limbo for what happens with the real estate.
And might it also be an alternative that we used to do back in the eighties and early nineties, where it's not just a joint administration, but you file them both and then move to substantively consolidate them. For the purpose of the bankruptcy, although you really still have, for certain tax and liability purposes going forward, separate entities.
Yeah, it'd be interesting to see what that confirmation hearing looks like when you have part of it dedicated to disposable income in one test and part of it dealing with
Yeah.
the regular chapter 11 and the voting and the additional provisions for confirmation that only apply to the regular 11 and don't apply to the sub 5. I think before we leave the eligibility, there's
Oh, I was gonna say, so now assume for the yeah, go ahead. Oh, is it that, okay. Oh. Well, I've never run into it. Have you? Neema?
I would say yes. I've had a debtor that filed individually. He accumulated debt from a prior business, and his mortgage on his home was also included. The reason that the mortgage was included because it was also collateral for the business.
Yes, Rick. That is you've
You
anticipated
are
exactly where we're
absolutely
going.
anticipating where we're
Where
going, Rick.
So assume you qualify, all right, initially. And then, like many debtors, I won't say most, but I will say many, because Randy keeps reminding me, the debtor is unable to try to get a plan confirmed. They either aren't trying very hard or they try very hard, but it doesn't matter. It all comes out the same thing. They're not getting their plan confirmed.
Or debtor says, based on their schedules and filing, I fall under the limit, right? There is some unknown amount of contingent, unliquidated debt out there, these potential creditors, and I dispute them anyway. But it turns out there's an objection filed by one of those creditors who says, here's the note, the mortgage, there's no dispute that they signed these documents, for example. Even if we fight about the calculation, was this applied timely or whatever, there is a minimum, and I've had this happen, of X dollars that really is owed. And they can't and don't dispute that amount. If you add that amount in, it pushes them over the limit. And I had this happen in that small window of time where the debt limit dropped back to 2.5. So that's also a possibility.
That's a possibility, but let's turn to Randy, and tell us about Judge Gunn's decision, where she was faced with this situation of limbo, effectively.
Yeah, so this is the National Small Business Alliance case that's in Jim's materials. It's, I think, 3 pages long. I recommend, especially the creditors' rights lawyers among us, to read it pretty carefully. It's a fascinating decision and a curious statutory basis. But before I get into it, I want to address Rick's question, because he said, what happens if they're not eligible? So the Chapter 11 case is commenced with the petition. there's one sentence in 103I, I think it is, that says for subchapter 5, the debtor may elect on its, so there's a box, literally a box on the official form that says, I don't have the requisite requirement, or I do meet the requisite requirements, but I don't elect. And then the next box is, but I do elect. So it's an election to be within chapter 11, but under subchapter 5. If the eligibility is determined not to exist, they're a chapter 11 debtor. Full stop. But what happens when the debtor isn't doing what they're supposed to be doing, or they're misbehaving, or there's appointment cause for the appointment of a trustee? It could be a whole host of problems where the case is just lingering. They filed their plan, but they can't get it confirmed. Only the debtor can file a plan. We'll talk about that. It's a bit of a nightmare for the creditors who are stuck because you can't terminate exclusivity under subchapter 5. And a trustee can get appointed over the business to run the business. The trustee can't file a plan under subchapter 5. So it can be a bit of a mess. Judge Gunn, in her decision, it's entitled Memorandum of Opinion in Order Revoking the Debtor's Subchapter 5 and Small Business Designation. So revoking what? Revoking the election. And the way the judge got there was in part through section 105. But she went through the parade of horribles that, you have this business and it should be in chapter 11 for the benefit of creditors, not subchapter 5 of chapter 11, but it's not. Trustee going in there isn't going to facilitate confirmation for various reasons. Dismissal was a bad idea. We'll get to conversion in a minute, but the court concluded that clause existed to revoke the designation. Part of her argument was debtors can elect, even if they start in chapter 11, but not subchapter 5, the statute changed, they can toggle to subchapter 5. There's lots of authority on that. So her ruling was, well, if they can opt into subchapter 5, then I can require them to opt out. So how do you force a debtor to change, or, amend the petition? Is it contempt?
Well, the art or artful attempt used by Judge Gunn was not to force the debtor to do it, because I think she struggled with that. She ordered that the election be revoked. She appointed a trustee and then directed the trustee to amend the petition.
I don't get that.
I don't either.
So this isn't, trustee doesn't have possession of property of the estate. The petition was filed by the debtor, not the debtor in possession. So how does the trustee even have?
Well, because the
authority over-
trustee has all of the powers of a trustee. Because they converted the she converted the sub 5 trustee into a regular trustee was the argument. I mean,
I'm trying to get you I'm trying to trap you into 105, so I'm not going to be able to do that. So
Alternatively, here in the Northern District of Illinois, in certain cases, we have seen judges elevating the subchapter 5 trustee's position and making them subchapter 5 trustee in possession, where they are now operating the business because the debtor has proven incapable of doing so. So, there are, I think, many creative ways to getting to the same place.
but
rather
you
than
still
revoking.
can't file a plan
as long as you're in sub 5.
because they were eligible and the eligibility wasn't revoked, and that's the only statutory requirement to be subchapter 5. So how do you unravel it? So the court went to 105. Here's one problem with 105. Section 1181A says the following sections do not apply to a case under this subchapter. Subsection 105D. 105D was put in the code to facilitate Chapter 11, and it's got a long list of things that the court can do in order to assist in moving the case along under 105. The subsection D talks about, unless inconsistent with another town, may issue an order prescribing limitations and conditions as the court deems appropriate to assure the case is handled expeditiously and economically and so on. But Congress said 105D doesn't apply. So Judge Gunn used 105A, which harkens back to, I think, Judge Carr and UNR and, a lot of cases where, you need to do something that is appropriate, necessary to avoid an abusive process. So here's the tool now for creditors if they're stuck in a sub 5 where the debtor may be misbehaving, cause for appointment of a trustee, can't get a plan confirmed, the only party that can file a plan. You can't get out of the subchapter 5 very easily. You can convert, but maybe you don't want that. So here's now a tool. It's the first case of first impression. Pretty interesting, I think. I still think it's a little weird to direct the newly appointed trustee. The first thing that she had to do was change the election on the
Yeah,
debtor's petition.
I mean, it illustrates the tension between poorly drafted statutes and trying to really accomplish the goals that we've got. Because it was clear in Judge Gunn's case and in a number of other cases that have come up that there are many reasons the alternative might simply be to dismiss the case. And that's not in the best interest of the creditors and most of the parties in interest. It actually might, however, be in the interest of the debtor or the principals of the debtor, particularly if you have avoidance actions and that sort of thing. They may be able to stretch things out long enough that if you then dismiss the case, there are those sorts of assets that are gone. And so what's the balance? What's the approach other than stretching 105A? And under 105A, my view is the limitation is I have to find a basis under the code to exercise that equity that I have as a judge under 105A. If there's not really a basis where I'm furthering a particular section of the code, I can't do it. But how do you accomplish that?
I think there might be an argument available, but again, it goes to your point about the statute not being as clear as it could on this point. But if Judge Gunn converted the case and then on her own motion converted it to 7, and then under 706B converted it from 7 to 11 with the trustee immediately appointed. So wrapping it all, step 1, convert, step 2, convert from 7 to 11 with a trustee appointed. Then of course the question would be, well, if you're back in 11, isn't it the 11 that the petition started with where the debtor checked the box to be subchapter 5? I think the answer is no. I think it's a different chapter 11. It's a case converted to 11 from the 7. And therefore, my argument would be that the election does not apply to a case that is converted to chapter 11 from chapter 7 from subchapter. But that might require a tweak to the statute.
There's probably many needed.
Okay.
So I think I'm done with the first part, and I think we'll move on to confirmation issues and the role of the trustee.
All right, role of the trustee. I feel like we're 3 years in and nobody really knows. I think, predominantly the role of the trustee is to be the intermediary, right, between the debtor, the creditors, the judge, the U.S. trustee, and try to help everybody along. So we're reviewing the monthly operating reports, the initial filing documents, helping the debtor understand the rules of bankruptcy and helping them draft a plan. So a lot
Oh,
of times.
owe me a fiduciary duty?
Right.
Sure.
Pretty much, we are the negotiating tool that most debtors seem to use when they can't seem to get into agreement with their creditors. Can you call creditors counsel for me? They seem to have a lot of issues with my plan. Okay, sure. We call creditors counsel. What's the issues with the plan? Let's try to resolve it. In many cases, when you have sophisticated counsel, the role of the trustee is really simple. Everybody kind of works together. They know what they're doing and they move forward to getting a good plan together. And in other cases, it's not always the plan. So, just working together to make sure we can get to a consensual plan. If we can't get to a consensual plan, I try to, encourage counsel, can you get your debtor to call their creditors? Let's just get people to vote. That's, task number one, because a lot of times if you don't get a vote, it's deemed rejected. So, try to get the creditors to vote on the plan, and then, in most cases, once the plan is confirmed, the trustee's role ends at that point.
I mean, it sounds like you're working pretty hard and I assume getting paid by the hour as you go.
We wish, we hope. That's the goal, right? To get paid at the end of the case. So, like in other districts, there are trustees who have retainers in place and things of that. But in our district, we have yet to see that. So I would say I've overseen probably 25 cases in the 3 years that Subchapter 5 has been in place. Luckily, I've been paid on probably 75 to 80%, but there are certainly a few debtors that you are chasing and hounding, and, I act as the collection agent in addition to being the Subchapter 5 trustee. So it just doesn't always work that way. So I think, as we said earlier, there are many tweaks needed because a lot of this is not, smooth moving just yet.
If you
Judge,
don't-
can I hypothetically, if a trustee filed a motion saying, I'd like to get paid currently, or I'd like to get a retainer, what's wrong with that?
I don't see anything wrong with it. As Neema mentioned,
Other
in
districts.
some districts,
Yep.
sub-5 trustees do get retainers.
Yep.
And my district is one of them. If you don't ask, you don't get it.
Yep.
But in addition, I have seen, again, in my district, where there's a carve-out that's been negotiated. And I don't know here whether, as the panel trustee, you're comfortable raising the issue.
Right.
Fortuitously, someone else raised it in a couple of my cases, and now it's pretty standard. If there's a carve-out, that carve-out applies not just to the debtor's lawyer.
And just
It-
like in a regular Chapter 11, I
just-
would never be involved in a regular 11 without a carve
Right.
out. So
So,
I think it's just a matter of time. A lot of our Subchapter 5 trustees here in the Northern District are non-attorneys. So we are still kind of navigating and trying to figure out what the right balance is. And, as I said earlier, we still really are unclear of our role. How much power do we have? What should we be objecting to? What should we be asking for? So I think it's, we have a weekly or a monthly call between us, and, a lot of this gets talked about, who's going to do it first.
well, and now as a secured creditor lawyer, Randy, when debtors negotiating with you on cash collateral, assuming they actually think about it, and now they want to negotiate a carve-out, how do you feel about that carve-out covering, or do you care? Not just debtors counsel, but also the panel trustee.
So, assuming it's a regular way case, you look at it and one of the biggest benefits, of this statute for the secured creditors, I don't have a creditors committee that we have to pay.
Right.
In a Chapter 11. And from a cost benefit analysis, the statutory trustee is going to be a lot less expensive. And I will also say it's a really bad look to tell the UST that you're not going to consent to a carve-out for the government-appointed trustee. So I don't suspect that unless we're trying to get relief from the automatic stay or dismiss the case or challenge the eligibility or anything like that, if we're working with the debtor, I think it's in our interest to make sure that that is taken care of.
Yeah, I don't think the UST in our district would raise an issue if the
Sure.
carve-out covered, the panel trustee. And for a variety of reasons, when the first request or two were made for retainers, the US trustee frankly didn't weigh in. And so now that's the practice in my district.
And I think it also comes down to the sophistication of some of these debtors, right? We have small business debtors that a lot of times aren't in debt with some of the bigger banks or the bigger creditors. They're involved with much smaller banks that are not familiar, and maybe this is their first time with a debtor in Chapter 11. So it's, it's kind of murky waters when you're dealing with, especially when the debt limit was low. You had, all sorts of folks. You had non-Chapter 11 attorneys filing Subchapter 5 cases. And, again, I'm a non-attorney trustee, but I'm trying to help them navigate through a Chapter 11. And that's not my role, so.
But what if your role gets expanded and you're given maximum duties under the statute? Now you've got to run the business.
Yep.
So you're going to be hiring advisors.
Sure.
That's a different game at that point.
Absolutely.
And your own counsel as well, right? Yeah.
Who's ready?
One of the duties that, one of the duties the statute provides you is facilitating a consensual plan.
What does that mean?
Well, I want to turn to that because there may be reasons why the debtor doesn't want a consensual plan, as we see. So, the requirements of a consensual plan under sub 5 are the same as under any other Chapter 11, with the exception of 1129(815). So to get a consensual plan under sub 5, you have to qualify, you have to meet all the criteria of 1129A except for which deals with an individual Chapter 11. But let's start with the first question of what do we do in the case of the so-called apathetic creditor issue? That is, you have several classes of creditors and essentially all but one, no one even bothers to show up to vote. You run into that problem at all as you're trying to put a consensual plan together.
Yes, and that's why I mentioned earlier, I am often saying, just call them. The first step is to get them to vote. And then we are in a different position. We are in a consensual plan. So.
Right. Well,
So you think voting and meeting those criteria is the same thing as consent? Aren't those two really potentially different concepts? Aren't there two different things? You get votes, so do you have at least an accepting class? But does that mean that those creditors who don't vote consent or didn't consent?
We're deemed to have.
Right.
that's the issue.
Yeah.
In some jurisdictions, you have to vote to consent. In other jurisdictions, your failure to vote might be deemed to be a consent. And you'll need to look at the law in your particular jurisdiction to figure out how they deal with the apathetic creditor class problem.
And in the
Yeah, and
in
in
the
my,
end,
and in
doesn't
my
even matter.
district, voting is voting. You do the calculation, do I have the amounts in number and dollar amount for those classes to have accepted the plan? But the argument's been made, and at least so far I've agreed with it, that failure to vote is sort of a separate analysis, and if you don't vote, I think you've accepted the plan because you got the opportunity, whether you vote or not, whether you vote for it or against, to still object up here and prosecute your objection. So if you don't want to accept or be bound by the terms, I don't care if you vote or not. But if you don't show up and object, I think we could, in that regard, in the right fact situation, say, if you didn't vote and you don't show up, you're deemed to have accepted.
And really then what's the difference? Just the timing of the discharge? Like, I've had counsel say, well, I don't really care. If it's non-consensual,
What
It's
about-
not just the
What about
timing.
your fees?
It's not just the
I
timing
still
of the
get paid
discharge.
sometime, most
No, but
times.
you get, if it's consensual,
Right, if
you
it's
get paid a
non-consensual,
compromise.
I would
Well,
get
but there are instances where the debtor really truly wants it to be a non-consensual plan and will look for a creditor to make sure it's non-consensual, because the other benefit from the debtor's standpoint is modifying the plan.
So
If it's consensual, it cannot be modified after confirmation.
Section 1193D states that a consensual plan may be modified at any time before substantial consummation of the plan in any manner that would not violate Section 1123, and the court approves the amendment. As a practical matter, consensual plans appear to be either unamendable, or exceedingly difficult to amend. So from a strategic perspective, this is why I raised the issue with you. Amending a crammed down plan under 1193C, it can be amended at any time so long as it comports with section 1191B, and that the requirements are simply that it doesn't unfairly discriminate and it's fair and equitable. So the flexibility granted to a debtor who does not get consent from the creditors to still nevertheless cram down a plan, the flexibility is greater for that. I don't know if Congress intended that, but that's the way it's written. And you have much greater flexibility down the road to amend if you run into issues than you do if you've gotten everybody to vote in favor of your plan. But we should probably talk a little bit about the difference in cram down between 1129, your normal 1129A and B, and what sub 5 provides, because there's some very interesting
Brian.
possibilities here.
Brian has
Do we have a question? I'm sorry, Brian.
Yeah, the question is that in sub 5, since you don't need an accepting class, do you even need to go through the process of solicitation?
just what we were discussing, right? I think you can go either way.
Well, you won't know if you have a consensual plan or not. So I think the answer is yes. And I mean, I don't know why the single impaired accepting class is taken out, other than my presumption that the draftspersons of the statute were looking at the single asset real estate case evolution that led to the having that one, other class as part of Chapter 11. And I know the ABI and the Reform Commission tried to do away with that requirement for all Chapter 11s, but it's probably going to not be all that relevant in most Subchapter 5s that you don't have that one impaired class, but you still have to see if the other classes are accepting or not for purposes of what, the requirements for confirmation versus contested versus non-contested case.
So to clarify, what we've been talking about is that section 1191B says that to cram down a plan, well, let's start with 1129B says all the requirements of 1129A must be met except for votes. And that that under sub 10, there must be a consenting impaired class. Under subchapter 5, 1191B says you can chuck that consenting impaired class requirement. So now, so this is what we're talking about. If you can chuck it, why would you bother even to vote? Why not just go straight to cram down? I don't practice in this area enough to know whether that makes any sense or not, but I will say that it's very tempting, given that you don't have to get anybody anyone in an impaired class to vote for your plan, you can go straight to cram down and get it crammed down. So, and then I think that covers what we wanted to talk about, cram down. The questioner kind of jumped right to the finish line on that,
Well,
so.
we should talk a little bit about the secured creditor component. It's fascinating to me in reviewing the materials and cases that have been decided, and not just in our materials, but in other materials. The ABI's got thousands of pages on Subchapter 5 already. There are a lot of 1111B cases. And I think part of the reason for that is there's no absolute priority rule requirement in Subchapter 5. So you've got a situation where the secured creditor wants its collateral, the debtor wants to confirm his plan, and the valuation fight is such that they want to cram down the secured creditor. The language in the code is the same for Subchapter 5 as it is 1121B. In terms of the treatment for my secured claim, fair and equitable. I hope the courts are not going to deviate. That fair and equitable means something different. In a Subchapter 5, it's fair and equitable to have a 20-year stretch out. In regular Chapter 11, 7 might be the max. So I put a case in our materials where the court had no problem with a 10-year stretch out. That would be a long time for a secured creditor, especially if they had a 5-year note to begin with. But the test is going to be the same. But if you're underwater and you've got your general unsecured claim bifurcated under 506, you're looking at what you're going to get under this projected disposable income test for 3 to 5 years. And that might not be worth it. You may want to say no. And by the way, the 3 to 5 year part doesn't modify the section with respect to the secured creditors. So as I said, secured creditors treatment can be a lot longer than that 3 to 5 year period. So if you look at the cases that we summarize and some of the other materials that are out there, there are a lot of 1111B elections because the debtor, at least in proposing these plans where they're really, I think, focused on everybody but the secured, they don't expect that the secured creditor is going to make that election. So for those of us that practice regular way Chapter 11s, it's really, really rare for a secured creditor to make that election because it's probably not that hard to meet the face value test and the present value test for the secured claim. But for some reason, in these smaller cases, maybe it's the values are so disparate, but there's a lot more elections being made, and they're blowing up the plans. The debtor can't meet the requirement, the $5 million note, and the debtor goes in and says the collateral is only worth $500,000, and the creditor goes, okay, 1111B, okay, and that's a tough issue. One of the cases, now that we're on 1111B, talks about when you make this election. So the interim rules, which I don't know enough to know when they're going to become final, but the interim rules acknowledge that since there's no disclosure statement, there's no rule that would apply that you have to make your 1111B election. It makes no sense to have to make that election before you see what the plan is. So you wait for the plan to get filed, and at some point, not being dilatory, you're going to make that election. The rule now says you have to make the election if a date is set by the date the court sets. So that's a great rule. But that's an issue because you got to know what you're getting. And to your point you made earlier, Jim, about modifying that plan, if that's not working out, you got to go all the way back. You're going to change the secured creditor's treatment. I think you have to give them another right to make another 1111B election.
I think so.
And
Yeah, and that debtor would probably ask that it be set before their plan is filed.
the question was, what about the debtor who comes in to ask for a deadline? Debtors do come in and ask for a deadline, but you're also beginning to see judges simply add into their standard procedural order deadlines and it's not necessarily a date certain. It is X number of days either after the filing of the plan and the solicitation or prior to the confirmation hearing. So more and more judges are anticipating that possibility and simply either inquiring, getting motions, or putting in standard procedural orders.
I think in the 20 or so cases I've overseen in Subchapter 5, I am pretty firm on you can't go greater than 5 years. I think like I said earlier, the sophistication of a lot of these debtors, you really question feasibility when you see something going out further than 5 years, because a lot of these debtors don't have that sophisticated cash management tool to really be able to say in year 7, they can, feasibly make these types of payments.
And I think to the point of sophistication, there is a lot of, frankly, variability in the sophistication of counsel,
Oh, yeah.
depending on, and more so on the debtor side than on the creditor side. And almost like the deer in the headlights when there is an 1111B election made, the debtor scrambles to try and figure out how you do the math. How do you discount to present value? How do you analyze and build the stream of payments? That's not necessarily something that's routinely done by a lot of lawyers who are doing the smaller sub-5 cases.
So what's happening then in these cases where the debtor tries but can't get confirmation? There's no termination of exclusivity. They're trying. Maybe they're on their 3rd or 4th plan. They still haven't been able to get confirmed. From a creditor's perspective, what do we do? We talked about this earlier with revocation, but that's sort of like based on bad acts and stuff like that. I mean, how do you get out from the creditor's perspective? Debtor can't get the plan confirmed. And at some point, there's no provision in the code for them giving up. So what do? You convert
Well,
the case?
I can't do that on my own.
Right.
I need a motion. Now, maybe it's a motion for relief from stay.
Yeah.
Or some kind of a modification of the stay. And I've seen those. And if there's cause, once that happens, and there often is in those circumstances, it's like the dominoes, the house of cards. And then motion to convert is something else. I see the U.S. trustee step in, sort of belt and suspenders, and say, dismiss the case because it's an abuse, and they're sort of stretching the definition of abuse, or alternatively convert it.
What about a sale as a going concern? Isn't that going to maximize value and protect jobs and do all those good things? And how do you, it seems to me anyway, that it's not so good for secured creditors necessarily to win that motion for relief and stay and go
Right.
take back their collateral and have to
But
foreclose on the
can someone other than the debtor file that kind of a motion? I mean, I've just confirmed one of those where, frankly, the plan all along for everybody's best interest was a 363 sale. They'd marketed, they'd done all the spade work before they ever filed the petition. They knew there were multiple interested bidders. And so part of my first day was schedule this calendar for a 363. And literally in about 30 days, they had an auction. They confirmed the sale. They paid off most of the creditors. I think the unsecureds from the sale probably will ultimately realize 70 or 80%, which is pretty remarkable. They got a couple of unsecured claims to sort out. Otherwise, the case would have been dismissed. And that's the ultimate goal. We'll do the sale, we'll dismiss, or alternatively, we'll then convert it to a 7, and that'll be the end.
You're assuming the debtor's kind of going along with that.
Well, yeah,
Yeah,
but the
in
question
my
is,
example, now I think we've come full circle. It's not happening.
the
the
question
debtor-
is, can someone other than the debtor
Neema will have her role expanded, so
Yeah.
she takes over the business and then
Trustee
can file a
possession.
motion to sell.
Yep.
As a going concern under 363.
I think in the Northern District, there's a case, Cité. That's a chain of restaurants where our Subchapter V trustee is doing just that.
And I'll definitely give you a carve out.
Right, that's interest of everybody.
With
Any-
respect to cram down, there's one other thing I didn't say out loud, but the whole audience probably knows about this already. That is 1129B does not apply in sub 5. So the debtor gets to keep the stock in the company or keep the interest in the LLC and discharge the debt and continue to own the company. So that's one of the big payoffs for going sub 5 is that 1129B, B2B does not apply. So
And the other weird quirk is that they don't have to pay their admin claims in full and cash on confirmation. Contested.
that's
and
not a really good thing at all, actually.
They can,
Well, sort of circling back now to the discussion about revocation, but then your later point about what's the remedy, what's the outcome where debtor's not gonna get to a plan. Isn't perhaps the different way, instead of revoking the election, doing exactly what you're suggesting, expanding the role of the panel trustee, and then having the panel trustee come in and say, I want to do a sale.
let the market bear.
Yeah,
Mhm.
I mean, doesn't that get to in some respects, the same end point and outcome without the machinations of talking about, can you really revoke the election and what does that mean? Or please convert the case from a sub 5 to a 7 and then immediately convert it back to a regular 11 and appoint a trustee.
And
Yeah.
all the administrative costs that go
Yeah.
along with doing that.
Yeah,
And the
I think it's
US
just-
trustee fees that
Ah.
you incur immediately upon getting out of sub 5.
Right, because they will go back.
Yeah,
Yep.
Right.
charge you.
Yeah, it's definitely challenging, but as I think we, glossed over a little bit, not that easy to get the court to expand the powers. Effectively, it's the same test for appointment of a full trustee under 11. You have to prove cause.
Yep.
So just, my going in and whining that the case is taking too
Yeah.
long isn't gonna cut it.
And you save all those UST fees. Now, we've only got a couple of minutes left. Are there either any closing remarks or any other questions? If not, thank you very much.
Thank you.
Yeah, oh, great. Oh, no, you're okay, you're okay. So, as we're transitioning into the next panel, the year ahead, where are we now and where are we heading? And they are getting all situated. I wanted to read the code for the people on Zoom, and that code is being displayed in the poll. You probably saw it. If not, the code is S522. That's S522. Oh, you're lost? Yeah, I know. Yeah. Guys, take it away.
Oh, we don't, yeah, we don't have,
We don't.
we don't have.
You don't have one? We don't have this. That's easy.
No. Except Hubert. We'll see.
All right. We'll be there in just a second. I drove a long way to get there.
Just stop it at the beginning.
Enough pens?
Yeah, I think some of them don't work. Do we have the green light? Can we go? Let me start.
You just say.
Yeah, let me start by apologizing. I had. Okay, close to the mics. I'm gonna apologize because I did have a tie on until I sat for 20 minutes in a parking lot that was supposed to be the Chicago Skyway. I don't know if any of you else encountered that, but what a mess. In any event,
drove from Nashville this morning, so.
well, I did drive, yeah, the first 550 miles were easy. It was the last five got me.
Great way to start, thanks.
Yeah, we're going to cover a lot of things, and we've been kind of inconsistent. Sometimes this panel's been advertised as the year in review. Other times it's been talked about as the looking forward to the year to come. And so I don't know, I tried to give it some academic credence by thinking about calling it the Janus panel. I don't know if you've seen Janus, the ancient Greek god that looks both directions. But then when I Googled it, all I could find is it gave rise to the word janitor, so. Maybe it's a Janus.
Clean it up.
I'm going to introduce our panel. My name is Jim Carr. I'm judge in the Southern District of Indiana, sitting in Indianapolis. And next to me is Melissa Root, who is a partner at Jenner and Block and the co-chair of their restructuring and bankruptcy practice. She also manages the Chicago office of that magnificent law firm. Next to her, to the left, my left, your right, is Professor Bruce Markell. None of these people need introductions, I know, but I'm going to do it anyway. He is the Edward Avery Harriman Law School Professor of Bankruptcy Law and Practice at Northwestern, former United States bankruptcy judge for the District of Nevada, and conferee of the National Bankruptcy Conference. I've known Bruce forever, and I was thinking about this as I was making that long drive and then sitting for 20 minutes.
Oh, boy.
On the Skyway. He used to teach bankruptcy law. Well, first he was in private practice. He was only in private practice for a few years.
10 years.
10 years. Okay. So I matched that with 38 years.
All right.
Then he was teaching law at the Maurer School of Law, wasn't named that then, Indiana University. So I did that. Then he was a bankruptcy judge. So I did that. I've just tried all the way along to, and now he's back to teaching. But we're going to have
Stay a judge.
We're going to have some scintillating conversation, I think, as we go through this.
And just to add to that, Judge and I have been on panels for over 30 years. I don't think I've agreed with him more than twice.
I don't remember the second time.
Okay.
I don't know what that was.
I set that up.
And then poor Jim Mesterholm. He's came into this gang of whatever we are. Jim is the managing director and the global co-head of the turnaround and restructuring services practice at AlixPartners. So that's who we have. And we're gonna talk about a lot of topics, and every time we stop to talk about this, we start to think about how interrelated they are. We call it the fault, the first part at least, the fault lines in bankruptcy reorganization cases. And we do that because what we've seen in the past year are an awful lot of actions taken that have created tension and threatened the whole notion that what we have in this nation is a uniform law regarding bankruptcy. Instead, creative lawyers have pushed the boundaries in a number of areas, and we're going to try to touch on those. We in our materials, we included an article from a report of the Brookings Institute written by Professor David Skeel, Skeel. And Professor Skeel takes a very provocative position that many of this suite of issues we're going to talk about have created and have the potential to create a populist backlash against the very bankruptcy system we're all involved in. And he focuses on 4 issues, 3 of which we're going to talk about. Forum shopping or venue issues, third-party releases, a la Purdue Pharma, and what's often referred to as the Texas two-step. We're gonna touch on those topics. And then in addition, we're gonna talk about at least one in particular, financing technique that seems to be used more and more in mostly small and medium-sized cases, called the merchant, what's it called, Jay? Cash advance.
Merchant cash advance.
What
Very
Professor,
prepared.
what Professor Skeel, what Professor Skeel
And always.
says is that this populist backlash comes about because of the perception that corporate insiders are directing the bankruptcy restructuring process. And he harkens back to some of the actions that were taken in both in the railroad reorganization cases and then in the 1930s. And in those cases, there was a similar perception that insiders, Wall Street people, were controlling those processes, and that gave rise to the Chandler Act. Some of the issues we're talking about now have stimulated legislative efforts. Whether they're going to generate anything or not, don't know. The first of these troubling issues that create these fault lines that we want to talk about are third-party releases. And we've said we're going to say a final word about third-party releases. I'm afraid it's going to be more than one word.
And I'm afraid it's not fun.
Yeah. Now, just to set this up, Melissa and I were both involved in the USA Gymnastics case. She represented the debtor, and I was the mediator in that case, or at least one of a whole chain of mediators. I was the only one that didn't get killed. And so was there at the end. And our reaction, I think, to this debate is a practical reaction. We know, and we'll talk about this a little bit, given the circumstances of that case, there was never any opportunity that we could resolve that case and resolve in a beneficial way, a way that was sought by the claimants. We couldn't resolve the claims of the 540 young women who had been abused by Dr. Nasser. And the reason was because of certain interconnections between the debtor, USA Gymnastics, which some of you know was and is the governing body for amateur gymnastics in this country, and the organization that selects our gymnastics Olympic team. Some of the factors, and then Melissa can elaborate on this more, were that the funding in that case was going to come from a number of insurance carriers, 8 insurance carriers. And in a number of cases, there were 2 insureds under those policies, USA Gymnastics and the United States Olympic Committee. And therefore, there was no way to get the top dollar, which is what everybody was trying to get, the top dollar that would be acceptable to those claimants, unless the Olympic Committee was released as well. And there was no way to give the insurance companies the kind of finality they were looking for by selling back to them the policies that provided coverage for USA Gymnastics without the consent of the Olympic Committee, because it was a co-insured. And finally, the entire existence of USA Gymnastics was dependent, at least arguably, upon the Olympic Committee being satisfied with the result, because they had the ability to get rid of USA Gymnastics as the governing body of gymnastics. So those connections cried out for a resolution that allowed for release of the insurance companies and the Olympic Committee, which obviously, for lots of reasons, wasn't going to file a bankruptcy itself. And therefore, our belief is to put Purdue Pharma and USA Gymnastics in the same basket is a mistake. Do you agree,
Right.
Melissa? And then I'm going to ask for Bruce to disagree.
Well, I'm going to first anticipate his disagreement to try to get ahead of him. So I think what
You both
Professor
know I agree
Markell
with
would
that
say
part.
is that, yeah, they're two very different cases. The releases in USA Gymnastics feel more appropriate. It feels like there's greater justification there. But, you know, all of that feeling, so what if there's not a code provision and a code hook? Well, then Congress should go in and fix it to incorporate some of those differences that we see between USA Gymnastics and Purdue Pharma. And what I would say is that they're both are, it's a false dichotomy. Yes, they're different cases. And yes, there are factors in USA Gymnastics that made those releases okay and appropriate that might not exist in other cases. But there's also a code justification for what happened in USA Gymnastics, in addition to the fact that that's a Seventh Circuit case, and here we are with Aerodyne. And I guess I would start by pointing out one other fact, that there were over 500 women who filed proofs of claim. About 510 filed proofs of claim, 476 voted, and all 476 voted to accept this plan. And the ballots that were sent out to these women included, in big bold language, all of the information about the channeling injunction and the third-party releases. But the other point I'll make, and this is the one that Judge Carr teed up, is that USA Gymnastics didn't have any assets other than its insurance policies. The only way for it to fund this trust was to buy back the policies, for the sell back the policies. That was it. And you had the insurer saying, well, we're not going to put money in if the USOPC and all these other additional and named insureds are hanging around there. And those parties are saying, well, you can't cut our rights off. We have contractual rights as additional insureds, named insureds under these contracts. And so one of the bases that we justified these releases was as a sale under 363. We were their interest couldn't attach to the sale proceeds, right? Because then we wouldn't have had sufficient funds to fund this trust. So what we gave them was essentially the equivalent of what they had from the insurance policies. And that was the benefit of the channeling injunction. So I think there was an independent basis under 363 to support the channeling injunction in USAG. We also, of course, we were in the Seventh Circuit, and I don't think anyone disputed that, one, these releases were narrow. We weren't releasing, you know, the whole world. And second, they were absolutely essential to the case. There is zero way that this case confirmed
And third,
without them.
all of the people getting released, well, the key people getting releases were making substantial contributions
Yes.
to the resolution of the case.
Yes. The USOPC put in its own money. Its insurers put in the money. I mean, there were contributions from the USOPC and the other parties that were released pursuant to the plan. And it ended up being 100% unanimously voted for and co-proposed by the Survivors Committee. But I do think still, this wasn't just a great equitable remedy that we made up that doesn't exist in the code. I do think that there was basis and justification, particularly under Seventh Circuit law, for what we did.
Mr. Markell,
Go for it.
Professor.
Well, thank you for that setup.
Let me say, first of all, I mean, I think the outcome in that case was spectacular, and kudos to everybody involved in getting it.
Can I say one other thing before you go there? We could have gotten virtually everyone to vote for it. So the releases could have been consensual. Problem was time. And these dollars were only available for a short period of time. So now go.
Thank you so much. My problem is more structural, if you will, and systemic, and that is, I think what you came up with was a great result, and I think, you know, if it were backed up by a statutory basis that was more related to what you did, it'd be a great statute, but I think that's just not there. And every new case in which someone wants a third-party release is an opportunity for a judge to redraft or draft the bankruptcy code in the image of that case, which I don't think is really good ways to proceed. Now, why do I think third-party releases generally aren't good? Well, I mean, first of all, I'm just channeling, so to speak, Ralph Brubaker, who's written on this and has been on this program before. I mean, first of all, what is a third-party release? Well, we're taking away from creditors their property, which is their right to sue other people who are not debtors. And I'm not sure, matter of fact, I'm pretty sure, I don't see anything that permits that in the code.
Well, I would say we do that every day. We take people's property away in lieu in aid of restructuring every day.
Well, and I hope this isn't being recorded, because I hate to see you hauled into court on that point in terms of trespass and.
Well, we take their
and
property
and
away, we
conversion.
take with, we
But,
take,
but my point is, when you have a plan of reorganization for which there is a settlement, and I know 1123B permits settlements of class, you have, what the code does is it says a class of creditors, and presumably they have some common economic interest, that the majority of that class can agree to the settlement with the debtor. That's what 1123B, I think, generally says. What you have when you bring in a third-party release, you're saying, not only that, but we're going to take property rights away from those people against others. And indeed, we're going to do so without really looking as to whether the individuals in that class from whom we are taking property rights away, we're prohibiting them from suing on recognizable causes of action. We're not going to do that without any valuation of what that might be worth. Because
That's
those
not
people,
true.
well, let's focus though.
so,
Let's
well,
focus.
hold, where in the codes does it say that someone who's getting the benefit of a third-party release has to go through economic disclosure of whether or not that's a good deal?
Yeah, but keep in mind that all we're talking about is minority rights, the rights of people who are not, and we're talking about the people other than the
They're only minority, they're
two-thirds
only
and dollar
minority
amount.
rights, they're only minority rights if you assume that the people voting for the plan would also vote for the release.
They
if that-
did.
if
I mean,
that's
they
the-
had to.
If that's the case,
It was
why
part,
did you even have bankruptcy in the first place?
it was
You
part,
would've
the
just
plan,
had
the release
just
was
had the
part of the
agreement.
plan that they voted for. So
And the Survivors Committee in Gymnastics took extensive financial discovery of parties that were receiving the third-party releases, which I think ultimately led the committee to counsel its clients.
And
to
again,
vote
in your
for.
case, as you pointed out, you had people who consented to that. If you've got people who don't consent to that, they consent to their claim against the debtor being compromised, but they don't consent in losing their rights against a third party. What's to stop your construction of how Chapter 11 would work from precluding from those people saying, you can't take away my rights to sue the insured, to sue the third party, the co-liability, the person who's liable and successor liability, whatever the co-liability may be. Again, touched on in previous panel, how much is a vote on a plan of consent to lose all your other rights against other people?
But I think
Again, well,
11
one other point, or one other point. And because again, you get there by a construction.
this is the topic we were only going to say one word on, by the way.
We have 5 minutes allocated for an outline, but. I mean-
So real quickly, I was going to say this point no matter
Yeah,
what.
Okay, say it.
But real quickly, again, the structure of the code is not that way. I mean, when Manville came down, kind of the progenitor of these third-party releases, Congress reacted and said, it's okay in asbestos cases. We're not going to say it's not okay or it's okay. That's an uncodified part of the statute. They just said it's okay for asbestos cases. They could have said it in a much more extensive way for other cases. And indeed, if you look internationally, You look at the recent changes to the English Scheme of Arrangement Act, the Netherlands Restructuring Acts, they specifically permit third-party releases. I mean, this type of thing, when you say, oh, third-party releases can be obtained through the structure of the equity powers in the court, I just think they're sufficiently important. They ought to be stated in the code so people understand what they are. Now, again, having taken that position, I have to take the unfavorable position of saying, yeah, some meritorious cases won't get resolved. People won't get the money, but that's not the fault of the participants in the process. That's the fault of having a bankruptcy system that is not sufficiently flexible to everything that possibly can be thrown at.
But we're going to talk about other topics today that also there's not a code basis. Like what in the code says that in a solvent debtor case, an unimpaired creditor should get post-petition
All right,
interest.
let's get to that.
Nothing.
Let's wait till we
know,
get there.
I'm just saying that
Uh,
there are.
What in the code
we-
says you can dismiss for
We
bad
read that,
faith filing?
and we have 1123A6, and I do think that allows courts to make this equitable determination between the USA Gymnastics of the world and other cases where the releases make us uncomfortable and justifiably so.
To try to keep us on somewhat of a track, let me finish with two things, and it's going to also result in.
I just don't have time.
He conceded it at a prior conference where we spoke
Here-
together.
Here are
so-
two last things I want to say about this. First off, in the article that we gave you, Professor Skeel's response to this is, because you have three choices. You either throw out third-party releases altogether, you allow them, or you do something else. He says, rather than simply banning third-party releases, a more nuanced response would be to insist that third parties seeking a release provide transparency about their assets and ability to contribute. I don't know if that helps.
Well, I mean, again, part of all of this problem is shifting who determines the ultimate liability. And that gets also to the Texas two-step. It also gets to everything that we're talking about. I mean, you brought up this point, and it's actually a point raised by the question. People want to get fast decisions faster than other court systems, state court systems, other federal court systems can get you final results. Bankruptcy courts have proved themselves very capable of doing that in mass cases. And that's what's being purchased, if you will, by these things, is getting quick resolutions. Now, I'm all for quick resolutions, quite frankly. If Congress could change, I would support putting third-party releases in the code. But I would want to do it on a systematic basis in which all federal courts are operating under the same rules.
Well, that's a dream.
I
Here-
agree.
here's
I
the-
agree.
here's the- here's the
It's not a nightmare, but I thought we weren't going to.
Yeah, we'd rather not do that for now, because if we do, we're never going to get through half of our material. The other thing I want to cap this with is, we have a case pending down in Indianapolis now. Some of you have heard about it. It's called the Aero Technology case. It involves over 200,000 former servicemen who claim to have been injured by defective ear protection devices. In that case, the debtor sought a preliminary injunction from my colleague, Judge Graham, which is sort of the predecessor to the third-party release. Get the preliminary injunction, stop the litigation, settle it, and release the litigation. Judge Graham refused to grant that preliminary injunction, and that matter is now on direct appeal. It's been certified for direct appeal to the Seventh Circuit. So there's going to be an opportunity to speak to this. I'm involved in that case.
At least to the injunctive aspects.
Yeah,
to
the
it.
injunctive aspect.
mean, the
I'm
third part-
involved, so is Melissa, so is Jim. So Bruce, comment on that.
I really loved it when they told me they were all conflicted out of this. Well, I mean, it's a horrible, all these are horrible situations, right? But this is a situation in which there are all sorts of possible plot lines that I think journalists are pursuing that aren't really there.
Yeah.
And to kind of get down to it, what happens is you've got 3M, which by the way has a net worth of
3M
about-
is the parent of.
3M is the parent of the debtor, if you will. 3M has a net worth of maybe $68 billion. And it was mired, and there's no other word for it, in a bunch of multi-district litigation
Still is.
hearings down in Pensacola. Yes, I know. You would rather be there, I know.
I would.
Well, you're supposed to be there now, aren't you?
Right.
Yeah, that's another
Luckily,
point.
I'm supposed to be here too.
Yeah, well, that's another thing I'll get to. And it's been over time, and 3M was not liking the results that they were getting out of the multi-district litigation, because again, multi-district litigation is just another way to handle mass claims. They have bellwether cases, they take cases, discovery 500 at a time. It's an interesting way to handle a multiplicity of litigation. But 3M was not liking it. The judge was not liking, I think, the fact that 3M wasn't settling. And so 3M, once they kind of got some indications from the district court judge that things to the effect of, and I don't know if this was said before or after the filing, but you can be sanctioned for bad faith in mediation in terms of when mediations didn't produce results. They filed a bankruptcy in Indianapolis for a subsidiary that actually had something to do with the earplugs.
Yeah, they made it.
They actually made them.
Well, I didn't want to go that deep, but at any rate, at the opening hearings, the lawyer for the debtor said, I don't think there's a single MDL in history that's as broken as this one. I'm blaming the district judge in the sense that there was a departure from case management standards that are used in other cases. So that kind of set up a jurisdictional battle, I think, that the press is picked up on, which is not quite right. Although it is pretty clear that the district judge there is not happy with 3M. And when I said that Judge Carr should be there are actually mediations going on down there. And when Judge Carr, he won't say this, but when Judge Carr said, listen, I've got a seminar I've got to attend to, the district judge's response was, so what? I'm ordering you to be in Pensacola.
No, I'm ordering the mediation to go forward. You can be wherever you want to be, Carr.
Right. So there's not a lot of, they're not, building a campfire and singing Kumbaya.
Right.
There's a lot of kind of, unfortunately, when you have this kind of friction, people will try and leverage it to their own benefit. But one of the things that happened, and one of the things that happens in these cases, especially in Arrow and the like, is that if the liabilities can be centered in this is kind of the Texas two-step, into a particular entity and severed out from, in this case, the parent or something else like that, what part and parcel of that process is some form of indemnification agreement, a contribution agreement, an operation agreement, an indemnification agreement from the parent. The subsidy, you file the bankruptcy, we'll fund your costs of the bankruptcy, plus we'll fund, in LTL, which is the J&J case out of New Jersey, we'll fund a couple $2 billion to pay the claims. We're not going to be liable because of third-party releases, but we'll put the money in this trust for this. You kind of handle these claims down here at bankruptcy court. The rest of us will kind of go on with our merry ways. And as Judge Carr pointed out, the precursor to that is before you can get to the plan that does that, you want an injunction saying stop all these actions against the parent so that the parent can participate in the bankruptcy meaningfully in terms of what the right level of contribution is. By the way, I view the level of contribution as the price for taking away the Seventh Amendment rights of the creditors, but that's another matter. So what happens to 3M's dismay is that Judge Graham, and it's a good opinion, if you haven't read it, I would commend it. The opinion says, listen, I'm looking at this contribution agreement and you agreed to pay everything. Not only did you agree to pay everything, all the liabilities, you also agreed to pay the cost of the litigation. So what's your harm if I let the litigation go forward? You're going to pay for that anyway. And so he didn't issue an injunction protecting the 3M parents. You debtor, well, again, it's it's attenuated in the sense that 3M was agreeing to pay for, was on the hook for paying Arrow's claims.
All right,
Right.
that's the end of that. We're
Right.
going to move on to the next topic. We'll
Merchant-
never get through this
Merchant
stuff.
cash agreement.
Merchant cash agreements. I know she is. I know she is. Yeah, we got too many people.
Yeah, we shouldn't be doing the topic because everybody knows something.
We try
So-
to avoid those.
So, I want to talk next about merchant cash advances. I don't know how many of you have encountered these. I first saw it in a case that was pending down in my court when creditors, what I thought were creditors, walked in and said, "We're not creditors." It was actually a cash use hearing. And the argument was, "Judge, you can't let the debtor use the cash because the debtor doesn't own the cash. We own the cash." So these merchant cash advance agreements are structured as a sale of non-existent, then non-existent, arising in the future, either receivables or revenues, okay? We all know about factoring. We've all seen factoring. Factoring is a sale of an existing receivable, identified receivable. And
You say that as that matters.
it does matter. And in a factoring arrangement, the buyer of the receivable takes the risk of whether the receivable is collected or not. That's factoring. This is not factoring. This, as I said, is either a sale of future non-existing receivables. And in the bankruptcy context, keep in mind, these are the receivables that arise in the future and are owing not to the debtor, but to the debtor in possession. So somehow a sale pre-petition of, if we're talking about receivables for a minute, because I want to talk about revenues in a second, a pre-petition sale of an asset that arises post-petition. And of course, if it were a lien, Section 552 would cut that off, right? But somehow we're supposed to give cognizance to the fact that the way they've structured this, it wasn't a lien, it was a sale. So we have but then I want to turn to the second part of this, because the ones I've seen aren't sales of receivables. They're sales of revenue. And in my mind, that ain't a thing. That's not a race.
Notwithstanding hundreds of years of
Hold on,
jurisprudence.
hold on,
Right.
hold on. I liken it to the box score. I mean, this is not something you find on a balance sheet. You don't find it on the left side of a balance sheet, you find it in a P&L, right? It's going to tell you what happened, not what is, not how many dollars there are. And there's a real, we included 2 articles with respect to this topic. The first was an article by Professor Kara Bruce, who's a professor at the University of Toledo. And
Oklahoma.
her article appears in the Bankruptcy Law Letter, which Bruce is an editor, on April 22nd. And at one point, she cites another article that characterizes this kind of sale of, actually, he's talking about even sale of receivables as being metaphysically challenging to even understand what we're talking about. We also included an article by 2 lawyers at the Andrews and Kurth firm who try to give you a list of those things you should do and not do if you want these merchant cash advance agreements to succeed. Interestingly, I'd never even heard of them until these cases arose in my court recently, but Professor Bruce tells us that there were $19 billion of these types of financings in 2019.
Compared to like 8 billion the year prior. So if you haven't seen them yet, you will see them. They're coming.
Yeah, I think they're coming. Jay told me he's seen several in recent days.
And I think, there's New York seems to be the favored law for these agreements. Oftentimes they're executed in connection with confession of judgment. And so this issue of whether they are, for a would-be debtor, are they a sale or are they a lease, as the judge said, it really goes to numbers of factors that courts consider, but who's holding the risk?
So
I mean, this is securitization for
hold
the
on.
little people.
right?
Yeah, it's super predatory.
Most of this is done on the internet. Most of it is done without actually signing documents. In many cases, the
Mhm.
quote buyer doesn't sign the documents. Article 9 of the Uniform Commercial Code sweeps in not just taking a lien on accounts receivable, but a sale of accounts receivable. And so even if you're talking about buying these things as opposed to taking a lien on it, you have to file a financing statement. You have to follow Article 9. But the way they structure these is advance money. They take a percentage of either receivables or revenues, and they take daily draws, and they keep taking draws until some number is achieved. And when you compare the number that's supposed to be paid back to the amount that was advanced for the sale of these revenues, it's enormous. So it raises a number of issues. The first issue that gets raised is usury. Obviously, if this is a sale, there's no usury. Usury only applies to loans and the interest rate charged with respect to those loans. But interest is, in these cases, is defined as what it costs you to get the money. So it's the difference between what you borrowed and what you have to pay back.
And actually, it's an interesting, I think, profitable analogy, because for many years in the consumer area, there are lots of cases recharacterizing the transactions as loans or parts of transactions as interest, which could be very much applicable to this context now. Because again, a lot of what this is just simply restructuring a transaction to avoid bankruptcy and to avoid the problems of bankruptcy.
You're going to see if you look at the materials, there have been two principal cases that get talked about a lot in this area. One is a case from the Eastern District of New York, and it sort of blessed this arrangement, which is why in every one of these documents, you'll see they attempt to choose New York law, because that's who they think is going to allow this. Another is a case from Montana called Shoot the Moon, and it was Shoot the Moon owned a group of restaurants. In the Shoot the Moon case, the expert on behalf of the debtor calculated what was then the imputed interest rate by doing what I just said, comparing what you pay back versus what you were loaned, as being somewhere between 82.7% and 175.5%. In comparison with Montana's usury law of 15%. So usury is an issue, and the essential test that you then have to apply to determine what this is a whole bunch of factors that have grown up to determine whether a sale is a true sale. And when you look at it, it really boils down to who bears the risk of collection. And because these purported buyers take as protection guarantees from the principal and liens on all the debtor's assets to secure what's required to be paid back.
Not just the receivables, but everything.
They have no risk virtually concerning the collectability of receivables. And in fact, as a result, the business model, and this is something Jay has seen, has generated layers of these. So one of these financiers will be followed by another and another until finally the debtor has sold perhaps more than 100% of the debtor's revenues. And because they have no risk, they can do that.
And they sing Springtime for Hitler.
Right.
Yeah.
Except they have a lien on everything and the guarantee of the principal.
Yeah,
But the
everything-
lien-
everything.
lien-
Every lender has risk, of course.
Yeah.
So we have usury, automatic stay, use of cash collateral, obviously. If you're not a creditor, you're not stayed. If you own these things, you're not stayed. There's no use of cash collateral if the debtor doesn't own it. Interestingly, PACA is an area. You can have,
Perishable Agricultural Commodities Act for
oh,
those.
yeah, I'm sorry. Thank you. You can have, I'm assuming everybody has sort of a working familiarity with PACA. We've all seen them. It's to protect the growers of perishable foods. And when those growers sell food to a buyer who may in turn resell it, a trust is imposed. And you can sell out of that trust those assets as long as it's a commercially reasonable disposition. But these PACA courts have decided that before you ever get there, you have to decide whether this is really a sale. When one of these commercial cash advance financiers finances the buyer of the commodities and purports to, in turn, buy the commodities when they're loaning against the commodities. And I'm going to give you a site that's not in our materials. S&H Packing and Sales, 883 Fed Third 797, which is a Ninth Circuit case, says that before you even get to whether or not this type of transaction is a commercially reasonable sale, you have to figure out what's a sale. And so they do the same true sale analysis, but they've reduced it to that one factor, the risk of who bears the risk with respect to those products that have been sold.
Collection.
Yeah.
I'd also point out that there's also a fraudulent transfer issue if in fact.
Preference, fraudulent transfer.
Well, but if the price that for the money lent is too high, you might very well have a fraudulent transfer issue that you can.
But,
We were
but
saying,
you don't,
yeah, that
but
the debtor might
preferences
be-
go away because you don't have a debt. If-
Right, but the fraudulent transfer, in some cases, the debtor might be better off conceding the sale so that it can then potentially attack it as a fraudulent transfer.
There's a lot more to be said about that, but I'm going to leave it there for a second. And Bruce, how about Melissa raised the idea about solvent debtors and make-whole provisions. Those are kind of related to financing issues that we've seen. What do you think about that?
I think Douglas Baird ought to be up here because he wrote a great article on it. What's happening is, and Melissa, on this panel, I don't think I should have to say this, but just jump in if you disagree. One of the things that happened with a lot of major loan agreements is that they're putting in things called make-whole provisions. And the make-whole provisions were basically saying, we're at non-bankruptcy law, addressing the issue, strangely enough, that at common law, you cannot prepay a loan. That there was a contractual right only to be paid when due. And so taking advantage of that, again, on non-bankruptcy grounds, taking advantage of that on non-bankruptcy grounds, people crank into their agreements formulas that say if you want to pay it early, you've got to pay not only the principal, but some amount. And strangely enough, the some amount usually kind of works out to be the amount of interest lost on the money that's been paid, because usually these are prepaid when the interest rates have changed. And in almost every case, that's exactly what's going on. The trouble with that when you get to bankruptcy is, as we all know, interest that is unmatured on the petition date is not an allowed claim. And so what's happened in several cases, in Hertz, in Ultra Petroleum, in others, miracle of miracles, there have been solvent debtors. These debtors have enough money to pay everybody in full. And then they come back and say, well, why shouldn't we get what we had under non-bankruptcy law, which is the right to get this make-whole premium? You bankruptcy court can't tell us we can't get that. Is that a fair characterization?
Yeah, I mean, I think the make-whole issue, I think, sort of turns the same way in both a solvent and an insolvent debtor case. I think the post-petition issue, interest issue, to me is more of a solvent versus not solvent case. But yeah, I mean, they're saying I get the I get my claim, otherwise I'm impaired. But I mean, that goes to the whole issue of plan impairment versus code impairment. And if 502 is saying you don't get unmatured interest and these make whole premiums are the economic equivalent of unmatured interest, well then, I know you disagree. The plan's not impairing you, the code is impairing you. And, but just as we saw in kind of the first round of these make whole cases, Momentum and Energy Futures, when it's like, well, you know, what does the indenture say about when it accelerates and this and that? There will be creative ways to get around this. And Ultra Petroleum, a ton of the briefing was on, you know, this calculation is so enormously complex that it's not really an interest calculation. Or the other one is, let's ignore the
Which
ipso
is,
facto
which is a
clause
weird
for a
argument, right?
second.
Look at all this stuff.
Right,
It's
yeah,
not what it appears to be.
numbers.
Don't look behind the mirror.
Or ignoring the ipso facto clause because it accelerates and it's due all at one time. Well, it's no longer unmatured interest because it's due in one lump sum at the front,
As of
which I think
filing.
has lots of problems. But these cases are often coupled with that second issue of, okay, well, what about post-petition interest in the case of a solvent debtor? And this might seem like, how many solvent debtor cases are there? But this issue is percolating in at least 3 circuits. We haven't heard from the Fifth Circuit yet in Ultra Petroleum. PG&E we got that decision in the Ninth Circuit, and Judge Walrath had an opinion on this in Hertz. And it somewhat goes back to what we were talking about with third-party releases. What do you do when the code doesn't provide you an answer? Because arguably, the code doesn't tell us whether a creditor, an unimpaired creditor, should be paid post-petition interest in the case of a solvent debtor. Now, it tells us what to do with an impaired creditor. We get 726A5 through 1129. But what about an unimpaired creditor? In most courts, I think most everyone would agree, this seems like a crazy result where an impaired creditor would get post-petition interest, but an unimpaired creditor wouldn't. But see the dissent in PG&E, which is like, no, sorry, the code doesn't provide for it. You should impair yourself and then you can get interest. But the trickier question comes down to, okay, so if we could get to the idea that some amount of the solvent debtor exception was incorporated into the bankruptcy code, what's the rate of interest that we should be paying an unimpaired creditor in a solvent debtor case? And you've got lots of different answers. Energy Futures says kind of whatever the court feels like is equitable. PG&E says contract default rate. Hertz says the federal judgment rate. Ultra Petroleum, to be determined, could create a circuit split with PG&E. And this, I mean, in PG&E, I think the difference was like $100-200 million. So it's not an
several hundred million.
insignificant, dispute as to, go
No,
ahead.
and it is different per jurisdiction. When I worked on
By the way, what was your role in PG&E?
I was the chief restructuring officer.
Yeah, so you know what you're talking about.
So, I also worked on General Growth Properties, which was another solvent debtor. And at the time, I thought that might be the only one that I ever get the chance to do, but PG&E came along. But in that case, Judge Gropper ruled, that we had to pay default interest as well. And so when we got around to PG&E and I was working with the same law firm, and I reminded them what we had to do in General Growth, they were like, yeah, but Judge Montali is gonna give us, a different ruling. And so it just didn't seem like the right way to go, because to me, it just seemed logically, and I'm not a lawyer, so I'll start there. But so I may try to gauge it on fairness and logic, which maybe isn't what we should be doing. But
Are you saying that's not what lawyers do?
But it just seems like the concept of, if you're saying somebody is unimpaired and you're not giving them the right to vote, then why shouldn't they get what their contract says?
Brian, we have 11 minutes left. Great. We have 50 minutes of material. Let's turn for a second to another one of the items that Professor Skeel pointed to as potentially creating this populist backlash venue, forum shopping. What do you think about that, Bruce? Is it good? Forum shopping, bad forum shopping?
Well, I mean, forum shopping, I think there's good and bad, and I think there's good and bad because I think of forum shopping as figuring out where to file that might not be, for example, the natural, or what's been considered over time to be the natural location, which is where someone is, quote, located. Put aside for a second.
Everybody's not located in Houston?
Oh, not everyone's not located in Houston or in Dover, Delaware.
Everybody's sitting up on the Skyway.
Yeah, right, well, everybody's everywhere. My kind of distinction is, and part of this has come out because as you know, there, Adam Levinson at Georgetown has come out and said that there's been an incredible percentage of Chapter 11 cases filed in 3 districts, over 50% over the last, I think 6 or 7 years. And that would be the Southern District of Texas, that would be the Southern District of New York, and the District of Delaware. And in my mind, some of those are bad, some of those are okay. The okay or good ones are, is what lawyers, I think, are expected to do. We know that there are different interpretations of different bankruptcy code sections depending on what circuit you're in. We heard people, well, we like Aradigm because of what it says for the Seventh Circuit, and we don't like California because of what what the Ninth Circuit says on that. I think that's what lawyers should be doing, is trying to figure out if you have a legitimate basis, as stated in the code, which is a pretty liberal statement venue, to pick the place where you think the law is. And I think that's good because ultimately we have a system for figuring that out, right? Everything gets appealed up to the Supreme Court, and the Supreme Court can set what the standard rule is. Now, that may take 10 to 20 years. That's the system we're bought into, folks. That's the common law. The bad concept of venue is when you're not trying to get a particular court, but you're trying to get a particular judge. And districts have done this through intra-district venue rules, or in the Southern District of Texas by setting up a subset of the judges to handle the big cases, excluding some cases from it. Judge Drain, who I think is an absolutely wonderful judge, got a lot of cases because he was the only judge in White Plains, and all of a sudden people started getting post office boxes and one-room offices in White Plains so they could file there. That type of, I want to get a judge, bothers me because I'm not sure that there is the same type of institutional or systematic way to correct that there is in the kind of the general way in which people interpret the bankruptcy code going forward. And I think primarily because it really instills in non-bankruptcy folk the idea that it's just a game. And if you got the money, you can play the game. If you don't have the money, you're screwed. And more and more, I think the Texas Two Steps and others are instances of where we as a bankruptcy industry have to be really careful about how far we're pressing our cleverness. Because if it gets to the point where people are actually thinking, oh, this is a bad deal, all we need is somebody on Fox News or somebody, to kind of come up and actually do something in Congress that none of us like.
And they're trying. And we're not going to talk about the substance of Siegel versus Fitzgerald, but when we were thinking about this, when you go back to the origins of the UST program versus the VA system, it's, for all of these reasons, that provided a potential basis for form shopping. Now that's still there and probably will be fixed at some point. But it is, I think it just makes people, particularly outsiders, uncomfortable with the notion that, well, let's be honest, we don't have uniform bankruptcy laws, but
Right.
whether they could be fairly treated regardless of where they're.
All right.
And
Yeah,
just,
but-
In our
I
final
have to-
final minutes, I'm going to throw it
I
to
have
Jim.
weigh in from the business perspective on this. You do want to make sure, and this might not be a popular response, but this is what we think about from a business perspective, is you want to make sure that where you're filing, the judge is experienced with large cases and is experienced with some of the issues that you're going to deal with. I filed a case, I'm not going to say where, but you can probably guess or look it up in my record. We filed a case in a jurisdiction that didn't usually get large cases. We had an RSA. The judge didn't know what an RSA was. The judge marked up the RSA and entered the order and entered it like she could overrule a contractual obligation or a contractual agreement between two parties. That pretty much wrote in that we're never going to file another case in that jurisdiction again. It actually caused the company to have to switch from a plan because the lender said, you can't dictate the recoveries that I'm going to give to junior creditors and just write it into a plan and make me contractually obligated to it without a vote. So that was, it ended up being that we ended up withdrawing the RSA. We had a restructuring that was going to save a bunch of jobs. And instead it flipped to a 363 and the creditors only bought the assets they wanted and the rest liquidated.
Jim, we just have a few minutes and one of the big topics we wanted to talk about were issues that were arising in the cryptocurrency cases and sort of a peek ahead at what we think we're gonna see. Why don't you riff on
Yeah,
those?
so I'll just, on crypto, I mean, we don't have time to do it justice. We could have a whole panel on it, but you know, the main issues that we've seen so far is it's a real lack of understanding of what it is. A lack of understanding of, you know, there's no regulation to guide how these things unwind. And that's creating sort of a massive amount of volatility that's causing a lot of things to move on momentum as opposed to on law or formula, or a view of what the underlying value is. There is a question, a lot of questions as to what is it in terms of a claim? Who owns it?
Or even
How
it
do
is
you-
a claim.
Right.
Yeah, how do you value the claim? You know, is it, you know, in the case of, you know, I believe it's in Voyager, I think, or it could be Celsius, one of the two, but there's an issue of where a lot of the underlying cryptos, one is Ethereum and the other is Bitcoin. Bitcoin has kind of gone down in value. Ethereum has gone up in value. Who does that inure the benefit to? The actual person who deposited the crypto in the system, or do they get dollarized as of the petition date? And that volatility or the riding up and down inures to the estate. You know, I don't think it's
It depends, it
clear.
depends, if you take the bank model, the customers are creditors. So when you put money in a bank, you become an unsecured creditor of the bank, and you lose your title to the money. If you use the stock holding system, the brokerage system, Article 8 of the UCC, then you've got an undivided kind of floating interest, and you've got a property interest in it. And so that's not been determined what that is with respect to crypto yet. Small program note, there's a new Article 12 of the UCC coming. It's passed, the ALI, it's going up to the Uniform Law Commissioners next year, be out, you know, in the wild, probably in 3 to 5 years. But back to that, again, in terms of if you're a customer and you're a creditor, remember that 502(b)(2) says that you determine claims in United States currency on the date of the filing. And the law in Delaware and New York, as I understand it, for example, when people file claims in foreign currencies, pesos, euros, you determine what the exchange rate was on the date of the petition. So if Ethereum, if Bitcoin's gone down, sorry.
Okay, I'm gonna give Jim the last word, because at least in my judgment, nobody has predicted anything with any accuracy regarding the filing of bankruptcy cases in America. So Jim, what's your
Yeah.
prediction?
With that lead up.
So it's funny, we actually do a survey every year of all of restructuring types and ask them, what do they think are gonna be the big drivers of restructuring in the coming year? Do they feel the market is gonna go up or down? I think every year people are eternally optimistic in this one aspect of restructuring, that everyone thinks it's gonna go up. Again, we had like sort of 70% of respondents believe that we are heading into a recession. People believe that that is going to drive more restructurings.
No cheering, please.
You know, but, you know, I would say if you're also one that follows the capital markets and looks at the maturity cliff that's on the horizon, anybody that had the opportunity to refinance and kick that down the road, you know, did during the last 2 years. So there's not the same level of maturities that are happening right now. So what's really going to have to drive more restructurings is those that were not smart enough to kick the can further, which, you know, I happen to now be the CRO of Cineworld that filed, and they're one that wasn't smart enough to kick the can further on time. You also, you know, you're going to have people who have real liquidity problems. And so there still is massive supply chain problems, you know, driven by, you know, still by COVID, driven by, you know, the war in Ukraine. Those two things have greatly messed up supply chains for many people. You know, I look at it like Cineworld and you'd say, well, why are they having a problem that they're having today? And it's like, well, it's not because COVID is keeping people from going to the theaters, it's because during the period of bankruptcy, or during the period of COVID, no movies were made. And so now they're at a place where those movies would normally be available, and the available film slate is something like 40% of the average year. So there's nothing to show, even though people can go back. And so it's a supply chain type of problem, even in an industry that you might not think of that as a supply chain problem. I'd also say SPACs. We're seeing lots of failed SPACs. I would say, do they all belong in bankruptcy? Who knows? Because a lot of them don't actually have debt. So you're just figuring out, but they've run out of money and they can't raise any equity and they don't necessarily have any assets to secure debt. We just worked on a company called Enjoy Technology that was that very story. We're, I don't want to say optimistic because it sounds, negative to say that in this light, but we are seeing a big pickup in restructuring activity, and we think that that's going to continue through the year. And as inflation is not going to be fixed quickly, and what we're doing to fix inflation does not create supply. It may slow down demand, but the broken sense of our supply chain right now is that you can't, even if we slow down demand, supply that's available of goods is not meeting even normal demand.
On that
Great.
happy note.
Yeah, I'm ready for you, Mark. No, great job, you guys. Thank you so much. We're gonna take a break now. There's coffee and water outside. I did want to read the code for the people on Zoom for this session. It's 2WG3. What? I'm gonna do that. Okay, the Consumer Breakout is in a different room. It's C50. It's downstairs. It's back in the corner by the locker room. C50. So everyone attending the consumer panel after the break, which will start at 3:15. C as in cat. Charlie. C as in Charlie. 50. No one's listening to me anymore.
I'll sit here. You want to see them? Bob here, you there, Lindsay at the end. Good to see you. Thanks for doing it. Yes. Still there. What's that? Still there. Hi, I'm Brian. Lindsay, nice to meet you. Thank you for coming. Oh, no, they're muted right now. I'll unmute. But yeah, just try to keep them, you want to speak into it. I'm just the best. So I have, yeah, so the ones that, the next one is this one? Oh, no. Actually, this is these. There's also the ACB. Yeah, that's not, so this is this one. Yeah, that's the one to start for this one. Okay. And then the next one is, I can forget, it's the ethics. So, and then No, no problem. This one's still. That's right. Perfect. Okay. Cool. Yeah, just, that's back. Okay, back, forward, 10. That's the, forward back. And if you choose over here, so you may have to just kind of like. How about this? There we go. Yeah. Just to your left. Yeah. Okay, perfect. Adjustment, too low, too high. Pretty good. Hey, Mark. How you doing? Twice a month, right now. I think the only thing the board pushing. I'll put beginning. The only thing I'll wait to takes it out. Sure. Except when people come and see me and they say, I have too much debt. I'll take out a old school, wooden ruler. And we'll put some kind of well, if we eliminate the entire annual interest expense, looks like you still lose money. So what else is going?
pretty much know when, he is holding off the Chicago study.
You know, I don't mind going to Houston in January. It's when I have to go with Pat in like July that it's not my favorite venue, so. Wanted to miss it.
We need a few people. Start.
I don't get to bring my own water.
A lot of cheat sheets there, Mr. Kuchman.
Just copy and stuff.
And I'm glad some people are sitting in the front of church or synagogue here, right?
It's not a dangerous place. You don't get called on something. Oh, that guy in that window is keeping his eye on you.
I think we lost everybody to the consumer program.
I don't think that's it. I'm just gonna all gabbing, drinking water.
They're enjoying cookies.
I can understand that if there's wine out there. It's not 5 o'clock yet. David Neff was supposed to be here.
He's here.
Was he?
Yeah.
Normally he sits in the upper deck.
I don't know where he's sitting, but I saw him standing like that.
I was looking for him upstairs.
Then you guys were gonna steal all my comments about, some stuff I want to say about courts and but they're gonna trample all over.
Yeah,
what I
they-
have to say. No, they got near it.
What was the theme of the venue?
Well, it was just one of the topics that looking back and looking forward. Yes, what they were doing. Here, would you mind coming closer? I don't need one either. They did a 60-second march through venue because they took way too much time on the first couple of topics, and so she started to talk about some things about why people pick courts, and that ties into one of the things that I want to talk about. Was 9 the last time I saw it. It was 9.
Tim, is this a Wisconsin game?
Packers Bears.
Packers Bears.
It was 9 the other day, Howard. Yeah.
You know. Ultimately, no one likes your quarterback.
Or your team, or.
No, I know that. I meant no one. He's a guy who made the mistake of speaking when he should have just been quiet.
Oh, that would be bad.
I've heard the name. We're gonna get going. For those of you on Zoom, we will continue the way we've been proceeding. You will get your code for the next session through a poll that pops up during the course of this session. We will have people slowly filtering in, but we're going to try to stay on time, and I'm going to introduce Ken Malik of Malik Remian, who is the moderator for this panel.
No.
Oh, Pat Nash is the moderator. Okay, I'm going to introduce Pat Nash from Kirkland and Ellis. He's the moderator, and he's going to introduce the other three panelists next to him.
Is my, okay, great. Good to see everybody on this late Friday afternoon, beautiful Friday here in September. I'm Pat Nash from Kirkland and Ellis, broad-based Chapter 11 practice, do a lot of debtor work, some plan sponsor work. With me on the panel here today is Bob Fishman, who probably needs no introduction in Chicago. Bob's been around for a while. I say that affectionately. At Kohn O'Connor now, but has been practicing as a Chapter 11 lawyer here in Chicago for a while. Bob will tell you how long he's been doing it. Broad-based practice. To Bob's right is Ken Malik. Ken has been in the turnaround business for a long time as well, does valuation work, turnaround work, financial advisory work, and things like that. And to Ken's right is Lindsay Henriksen, who is a rising star at King and Spalding. I'm working across the table from Lindsay in a big Chapter 11 case now. Lindsay also has a broad-based practice, but spends, I would think it's fair to say, a majority of her time representing creditors, secured lenders. And so Lindsay will be bringing that perspective to our panel here this afternoon. And the topic of our panel, can Chapter 11 serve the middle market? So in terms of the slide, I don't know that our slides are so tailored, or it was hard to come up with slides for this panel, but it really kind of emanated from a thought that I had, which was, when you think about how damn expensive Chapter 11 is today, and you think about what it just costs to put a company into Chapter 11. And if you file a company for Chapter 11 and you impair unsecured creditors, you get a creditors committee. And it's now par for the court. The creditors committee gets a law firm. If they need a local law firm, depending on where they file, they get 2 law firms. They get an investment banker. They get a financial advisor. I mean, it is very expensive to file a company for Chapter 11. And if you're a multi-billion-dollar company and you need to restructure your balance sheet, you're going to file for Chapter 11. But, what about what we think, when we think of a middle market company? And of course, there's a middle market company, a small cap company. These terms are subjective and different depending on where you are or your perspective. The middle market means different things to different people. But I certainly had a sense from what I've been observing anecdotally that company, couple $100 million of debt, certainly $100 million of debt, increasingly, I've been doing this for 26 years. Increasingly, in my experience, companies are looking for any alternative other than Chapter 11. And companies, I think anecdotally, are avoiding Chapter 11 because it's just incredibly expensive. And the balance sheets of companies are totally levered up. There's been so much free money for so long, as we all know. If you've got an unencumbered widget, someone will give you a lien on it. And by the time you get to Chapter 11, the balance sheet is fully leaned up with secured debt. And if you file for Chapter 11, you're going to be doing whatever it is your secured lenders tell you to do. And, is Chapter 11 still a useful tool for a smaller or middle market company? ? And, I don't know, Bob, I'd ask you to give some thoughts.
Well, this topic is not one that's driven by a statute, it's not driven by cases. It's driven by the practicalities of the marketplace, and there's not a lot of control over the practicalities of the marketplace. I think that Chapter 11 for the non-billion-dollar companies is in danger. I think it's in danger in the short run and the long run. The cost has gotten to be close to unbearable, and in large part, a significant contributor to why Chapter 11 has become a not very effective tool for the 20 million, 50 million, and $100 million companies is on us. It's on us as professionals. We have lots of debtors lawyers who file cases that should never be filed. I guess we've always had a little bit of that, but I'd say there's more of it now than there used to be. Because of the lack of demand for the use of bankruptcy professionals, because of the paucity of cases, overstaffing and therefore excessive expense has become the norm. And I'm not saying that people are doing that on purpose as much as that's just what happens when you only have a little bit to work on. We have lots of creditors committees who pursue what I consider to be weak claims. The whole philosophy of creditors committee is now hold-up value. What can I come up with? What controversy can I create to get some money for my out-of-the-money people? And I don't think the system was created to try to get money for out-of-the-money people. And the more time we spend trying to create that kind of controversy, the less effective I think Chapter 11 is. Secured creditors have become so comfortable with controlling the process that they often don't make room for other people to get something that would allow the case to proceed more expeditiously and more efficiently, and in my opinion, would likely result in everybody doing better than they do when the secured creditor digs in and says it's all mine. And lastly, and the panel before us touched on this just a little bit, I think courts are at fault. Courts are at fault because there are jurisdictions that are hungry for business. They want the cases and they create environments that allow the cases to come to them. And that environment is fostered by courts having a cooperative view toward a particular kind of process. And that particular kind of process is sort of created to assist identified people, particularly the secured creditors. And I think that it's much less likely in today's environment for a judge to put his or her foot down and say, that's a line we're not going to cross. I'm not going to approve an order that says that. There seems to be too many courts that are willing to just go along in order to keep the flow of business coming to their jurisdiction. So, I mean, I think those things are all reasons why the prospect of Chapter 11 for small companies in the future is a little bit dim.
Ken, how about you?
I agree. There's no liquidity cushion left, especially for a middle market company. It's only in the bigger companies where you can do a legal sleight of hand, put some assets in an unencumbered subsidiary, that there's any source of liquidity and fresh borrowing. So the secured lender controls the process. It used to be that you filed for bankruptcy, the company got some breathing room, you cut a deal with the secured lender to use cash collateral, you fixed the company, you were reporting on a regular basis to the creditor constituencies what your progress was on fixing the operations, and you put together a plan within a year. And the unsecured's got some level of recovery, and the secured lenders, their price apiece was supporting the plan. Not the case anymore. The secured lenders tend to think that the marbles are all theirs. Lindsay?
And I guess I'll take the lender-friendly side here and say that it's not necessarily that the lenders are trying to screw over the unsecured creditors or those who are left without any assets or, things that are unencumbered as value to the company. But also, when you have a middle market case, debt is generally more closely held. It makes it a lot easier as a lender in a smaller group, a smaller consortium of lenders, to go to a company that probably also has a smaller management team and not so many parties and interests that are all fighting for different slices of the pie, to say, Chapter 11 is really expensive, not just for your team, but for our teams as well. We all have lawyers and accountants and other people that need to get paid here, and we can do this cheaply, or at least not as expensive as Chapter 11, if we come to a consensual arrangement out of court. And I think that's something that's harder to do when you have mega billion-dollar companies with 17 tranches of secured and unsecured debt, and there are so many more parties and interests that have to come to the table versus these smaller companies, not small necessarily, but that have a syndicate of lenders that you can realistically get 100% of lenders on board. And even in a lot of cases, the sponsor or equity holders to say, this is how we can reorganize this company without kind of running it into the ground with professional fees and other types of things that, so long as it's a debt restructuring and not something that needs to be effectuated through a Chapter 11, can be done cheaper and more efficiently outside of court.
So thank you, everybody. The slide that we have up on the screen, what's fascinating about this to me, I don't know how relevant it is to the topic, but look at how many bankruptcy cases were filed in 2011. And only a sliver of them are actually Chapter 11s. But look at how many cases, were filed in 2021, and I guess we're midstream or getting to the end of 22. And what that says to me is that we came out of, the Lehman Brothers, triggered financial crisis in 2009, 2010. And we've all experienced over the last decade, this easy credit, easy money, the Fed just priming the pump. And that's got to explain, the dramatic drop in bankruptcy cases that have been filed over the last decade is because if you're a company that, requires liquidity or whatnot, it's available. Chapter 11 is something very much of a last resort. And if we turn to the next slide, this is fascinating. When you look at what's going on in the economy today, it sure feels like restructuring professionals writ large should be busier. Mortgage rates are at 6%. Inflation is at a level we haven't seen since Jimmy Carter was president. And yet, while there's pockets where people are busy, there's certain restructuring professionals who are busy, a lot of us just aren't. And, I'd ask you, why do you guys think that is? There've got to be companies out there that back, in the 90s or whatnot would have been looking at the current economic landscape and saying, this is an opportunity for me to restructure my business. And yet, we just don't see it. And I, for one, don't think we're really going to see it. I remember years ago when you'd be on the circuit and at cocktail parties and people would say, oh, when do you think we're all going to get busy? And we all, 2 quarters from now, hope springs eternal. I've gotten to the point where I say, I don't know. I don't know if we're ever going to get busy again. Because, and I would tell a young lawyer today, if a young lawyer, hey, I want to be a restructuring, some law student, I want to go into restructuring. I think, I don't know. Do you? How about crypto law or I don't know, something that's going like this, not something that at best is going like that. What do you guys think?
Well, right before COVID, right when COVID began, of course, most people prognosticated a tsunami of insolvency work. And I was probably as optimistically guilty as anybody. And of course, it didn't happen that way. In fact, just the opposite happened because money was so readily available that you didn't need to go that route. And I think somebody in the prior panel said, nobody should be in the business of prognosticating the future of bankruptcy business because we've all proved to be so terrible at it. And so my thought is, unless there is an approach that the bankruptcy community can come up with that makes the bankruptcy cases more cost effective, I don't think there's any particular reason to think that it's going to be the go-to mechanism that it used to be when it was a much more well-oiled machine, in my opinion. And so I'm not particularly optimistic that there's going to be a return to the heyday of a lot of bankruptcy cases.
Part of the reason we're seeing such a low level of bankruptcy filing today is because the government actually did a really brilliant job of managing the PPP loan money giveaway. How did they do it? They didn't do it. They gave it to the banks and they let the banks administer. So the banks just funded their customers who needed it. And that was a brilliant approach. As a result, we've seen an surprisingly low level of Chapter 11 cases and financial defaults throughout the period of the pandemic. Now that we're coming out of the pandemic and the PPP money benefit is running out, you're seeing supply chain issues like Jim Mesterhar mentioned with theater companies being supply of movie constrained and therefore, seeing severe problems at the revenue line. So I think there's going to be some comeback, but it's mostly going to be out of court for middle market companies because Chapter 11 is too complicated as it is today.
I agree with that. I guess the question is, are we busy on Chapter 11 cases or are we busy generally? I spent most of the last year, as I bet a lot of people here did, working more in the private credit space and less in the restructuring space, and saw the sheer amount of money that was just given to companies, handed out, that maybe shouldn't have been. I know we documented some loans even in January and April of this year that have already defaulted on their Q1 or Q2 covenants. And so I do think there are a lot of loans out there and companies out there that are struggling. But in the covenant light world that we're living in, where sponsors for the past couple of years and private equity firms have been able to put whatever they want in the document essentially, because there's so much money and they can kind of pick the lender that they want to give it and say that these are the documents that you're going to live with, more or less. I think that there's less run up to when the company is going to be out of money and the traditional time that you would spend being able to analyze, should we file for Chapter 11? Should we do this out of court? Does the sponsor want to be able to put in money and retain the keys? Is the lender going to take it? We don't have so much of that buildup anymore. And instead we have a 2-3 week period in which a company is going to be out of money. And so the choices are, do we just give it away to the lenders now, which we can do quickly and efficiently out of court? Or something that I think I've seen recently that you guys can speak to as well, more companies that are filing free falls instead of prepackaged cases in which they've had the time and energy to be able to use the time before filing to get something documented with their creditors.
Well, let me ask the panelists though, that it occurred to me listening to this, that the tone of this panel is that this is a terrible thing. There aren't any Chapter 11s anymore. And I guess for us as practitioners, it is a terrible thing. But is it? Look, if lenders want to lend money to private equity firms, and if they want to give private equity firms, leverage with no covenants and companies don't file, I mean, is that a bad thing necessarily?
Well, I've always thought, in spite of the fact that lenders can be difficult to deal with, that they have their legal rights and they're entitled to enforce their legal rights. And there's nothing wrong with them making a business decision that they want to go left instead of going right, like the debtor might want to go. And I think part of what's happened is the lending community has determined that they can better utilize their money by putting a quick end to an insolvency situation, getting out of it what they're going to get out of it, and putting that money to use somewhere else, doing something else, than the battle and the cost of going through a Chapter 11. And unless, as an analyst for a lender, you can show that the more complicated, more expensive, more problematic route will result in an identifiably better return for you, there's really no reason to take that risk. You might as well just get your money back and go on to something else.
Part of it's a function of the regulatory process. If you look at a bank's call report, it gets severely dinged if a loan is in restructuring. If it takes 60 cents on the dollar, flushes the debtor and moves on, it gets full credit for the money it's relending.
I think it also depends a bit on whether jurisdictions, and this goes to the last panel, are going to be able to do what the Southern District of Texas did with large complex Chapter 11 cases and make it a very venue favorable place for Chapter 11 companies to file. Is there a jurisdiction that can somehow write a middle market complex rules to attract business where maybe it's easier to reject leases on a shorter time frame? All of this within the framework of the bankruptcy code, but is there a jurisdiction that can make it cheaper for middle market companies to file? And I don't know the answer to that, but there are still going to be reasons that you need to go into Chapter 11, reject leases, stuff like that. But I had a company recently where we were going to file the company purely for the reason to get rid of burdensome contracts. And as a last ditch resort, it was a one lender deal. We went to that contract counterparty and said, we don't want to file chapter 11. You don't want to file chapter 11. Why don't we renegotiate this now instead of us having to go in and reject your contract? You're going to get better terms, as are we. And we were able to avoid chapter 11 in that respect as well. So I think it's going to be interesting to see where those outside cases of what do you use chapter 11 for now, how are those going to continue?
You know, Lindsay, because you and I talked about this when we were getting ready for the panel, but maybe give some of the lender perspective on the kinds of things that you get pushed to consider, you know, short of chapter 11.
Creditors committees are the big one. That's, I think, the number one concern when we're coaching a lender on how to go about negotiations with a company, whether out of court or in court makes the most sense. And the number one concern that gets brought up to us is how much is a creditors committee going to cost? Is there something that we can do to pay off trade ed, to make sure that the unsecured groups are as small as possible so that if we do have to go into chapter 11 for whatever reason, we can minimize to whatever extent we can a creditors committee not getting elected. And I think the other things that the lenders are really looking at are, is this the company that I want to own? Because if it's not a company I want to own, then probably chapter 11 is going to be something we're going to have to, you know, I think this is one of the big topics of our panel is whether a 363 sale is still something that chapter 11 serves its purpose instead of a plan of reorganization in which we're going to come out and sponsor and try to be the owners of this company. And regulatory concerns are another one. That's something that generally a lender doesn't want to take on outside of a chapter 11 process. Rejection of contracts, one that I've already mentioned. I think those are the big ones that really push towards either a chapter 11 process or something much simpler, which is maybe we just try to negotiate a handover of the keys outside of court because we don't have regulatory concerns, burdensome contracts, or, you know, other internal organizational things that we can address through just the UCC foreclosure process.
I think the duplicity of costs is a big problem with chapter 11. And back during the period leading up to the enactment of BAP-CEPA, there was a lot of discussion within the professional community and with the legislators as to whether we should move to a single FA licensed insolvency officer type of model, as opposed to each stakeholder gets its own set of professionals.
But then who gets to hire that officer is another concern. I think that's a question of, if the company's hiring that officer, the lenders are of course going to feel like that's their person, you know, why don't we get our say? Because what if they've been tied to the company too closely? And vice versa. The company's not going to likely trust someone that the lenders have appointed.
Yeah, but what's interesting is, you know, we've all seen this where you're working with a company that's got $800 million of debt. You find yourself in chapter 11 because before you filed, you ran a 12-month marketing process and you got 3 bids, the highest of which was $450 million. The company's totally leaned up. So you file chapter in these lenders have the lenders have a choice. We can run a 363 sale and take a big haircut, or we can, equitize and take ownership of the asset. So let's say look, we just ran a 12-month process. We don't think we need to run a post-petition process. So we're prepared to equitize. Then you get a creditors committee, and they get a banker, and they get a financial advisor. And they're like, well, what are we getting? Well, you're not getting anything because you're not entitled to anything. That used to work, but now, well, we got to investigate the sponsor. Okay. All the sponsor did was lose money. They took out management fees. Okay. All right, here we go. Run the clock. I mean, Bob, Brian, please. Definitely. Should be 100 million. Should be 200 million. 7.5 million, 10 million. I mean, it's a joke.
it's probably a very good idea. It's obviously emotionally a big paradigm shift. I know that intellectually, people will say it's a good idea, but when it comes right down to it, the people who represent creditors committees aren't gonna like it. Many of the secured lenders aren't gonna like it because some of the things that they use to leverage their positions in a normal Chapter 11 case aren't available to them in a Subchapter 5 case. And
Like
you're-
what?
you're-
What are those? I'm curious. I'm not, sorry to put you on the spot.
Well, impaired accepting class.
Okay.
There is no provision for creditors committee in a Subchapter 5, and in a $7 million case, that's not that big of a deal. In a $50 million case, I suspect that would meet with a lot more resistance.
Yeah, fair.
Cram down is eminently more easy to accomplish in a Subchapter 5 case than it is in a regular Chapter 11 case. And that's certainly great from the debtor's standpoint, but not every secured creditor in every context is going to think that's great. And I know for sure that not every unsecured creditor is going to think that's great. In a small $7 million case, the amount of money that any one unsecured creditor is owed is relatively modest. In a $50 million case, you might have unsecured creditors with some serious claims who want to have a serious voice. So, I mean, I'm not opposed to it. I just think it's going to be an emotional adjustment that people aren't ready to make yet. There'll be efforts. It might, but interestingly, it could, if handled well enough, create an environment more like the one that I grew up practicing in, which is the creditors committee wasn't looking for a way to become an obstacle to the furtherance of the case and to get money where it's out of the money. Of course, in those days, the unsecured creditors weren't necessarily out of the money. But when you're out of the money, then the benefit of a creditors committee is what can I come up with to create an opportunity to get money that isn't about my place on the food chain when you do the value prioritization. And in some cases, you've got legitimate claims that need to be investigated and pursued. And in a lot of cases, excuse me for feeling this way, you have bullshit claims that need to be investigated so that some attorney representing your creditors committee can bill $1 million, but there's nothing there. And all they're trying to do is hold up the process to both make money for themselves, which is, I don't think, what we're supposed to be driven by, and to get a couple of shekels for the unsecured creditors, which you probably could get in a much easier way if you didn't create the obstacle first, but you really went and said, let's just streamline this case by providing a modest return to us so that everybody can get about their business and be done with this in 6 months.
We have to be practical here because if you look at the trend in litigation, historically, the biggest litigation recovery that redounded to the benefit of unsecured creditors was a 548 recovery action for a fraudulent conveyance or something similar. And now with the recent jurisprudence in 546E, that boat has sailed. And so the creditors committee, I think, are left to being obstreperous and difficult in extracting hostage value. And instead, if we were to shift more to a subchapter 5 paradigm, there the recovery comes from improvement in operations by letting the debtor stay in possession and fix its business and ride out the recovery.
You are.
There aren't many people in the room, so you may not be. Couldn't agree more.
But that actually. That plays very well into Jay Jaffe's point, which is if you were in a case that had enough unsecured creditors that they wanted to try to get a committee, and you could come to a court and you could show enough basic information about these transfers that you say are blatant, most of the bankruptcy judges that I'm familiar with will recognize the potential validity of those kind of claims, might well recognize that the committee is the only party that could bring them, and that might be exactly the right case for a creditors committee to get appointed. But if you appoint one automatically every time, their job is to create obstacles and generate money, not to prosecute legitimate claims. If there happen to be legitimate claims, great. But if there are no legitimate claims, then we're gonna prosecute weak claims because it's all we got.
And most, I don't have a percentage for this. Most companies that need to restructure and find themselves in bankruptcy, whether it's Subchapter 5, Chapter 11, it's not because of insider stuff. You know, it's the exception. It's like, you know, the McDonald's story where the person, you know, 3rd-degree burns when they had hot coffee, like the tort lawyers are like, see, you know, and it's like, okay, I get coffee at McDonald's every day. It doesn't happen to me. You know, like you can always point to a case. There's a case where an insider did something bad, right? Well, guess what? That is like a smidgen of the everyday companies that need to be restructured. The insider stuff and all this, we got to look into this and that. 99% of the time, it's nonsense. I see somebody has a question. %. I think Lindsay, you see that a lot, right? The
Yeah.
companies, why don't you talk a little bit about that?
I mean, Article 9 sales have been a lot of what I've done in the past couple years. And a lot of that is because traditionally what a sponsor or owner of a company wants out of a Chapter 11 is releases. They know that they're generally maybe going to get a small tip, maybe a little bit of the equity if it's something that's going to go forward. And, there might be warrants or something that they can try to get out of it. But in a lot of circumstances, they know that the main thing that they're getting out of it is releases. And there's so much under Article 9 that you can do consensually, and there's so much flexibility that even if the lenders themselves are not taking it, if they're selling it in a public sale or strict foreclosure, even a private sale, you can build in those releases for the sponsor or the owners of the company in a way that makes Article 9 quick and efficient and gives them what they would want out of a Chapter 11 anyways. And so I think that Article 9 has become something that, you know, I haven't been practicing as long as some of these guys on the panel, but even at the beginning of my career, that was not a tool that most lenders knew about. And now I have clients who come, and that's one of the first things that they say. They say, we definitely don't want to do a Chapter 11. What are our steps for foreclosure here? Do we have a holdco such that we can get the pledged equity, just foreclose on that? Because as I'm sure you know, there are complications if it's the type of company that has real property or things that you can't foreclose on. But I do think Article 9 is a very legitimate alternative now to Chapter 11 that was not such the case a few years ago. Mhm. Yeah. And if it's consensual, you can generally get the high level diligence that you would want out of a Chapter 11 M&A process anyways, to be confident that there's not so much liability sitting out there that you're going to get surprised by something environmentally or otherwise once you do take the keys of the company.
But that almost by definition means unsecured creditors aren't going to get anything, whether they have some modest right to get something or not. They're not participating. Seems to me that if an organized group of unsecured creditors felt like there was something in that case for them and that the Article 9 sale was about to occur, that's a perfect opportunity for somebody to file an involuntary so that you can get in front of a bankruptcy judge and at least give a shot. And whether the shot you're giving is because you got a real claim that you want to pursue, or the shot you're giving is we know what we get in a UCC sale, we might as well pick door number 2 and see what happens. No, I don't even know what the next panel is.
But don't. It's on involuntaries. But don't most unsecured creditors just, not bondholders, not unsecured bondholders, but I don't think we need to be sympathetic to unsecured bondholders. You know, they made a decision to loan money on an unsecured basis, you know.
Get what you get.
You get what you get. I mean, most unsecured trade creditors just do better if the company survives. You know, but they get into a room and they get some lawyer who says, oh, you know, you're getting screwed. You know, we got to go after these guys. Whether it's an Article 9 sale and that's the way that you transition the ownership from a private equity sponsor to now the lender or whatever, you know, the whole point of Chapter 11 is for the company to survive. Something happened along the way where, you know, these cases are now being dictated by the professionals. And they're also, in the bigger cases, being dictated by 32-year-old masters of the universe who seem to think that Chapter 11 exists to facilitate, you know, their latest trading or hedging strategy. And they're very disappointed when they find themselves in Houston or Delaware in front of a judge who says, look, I'm going to confirm this plan. Oh, you can't confirm this plan. Why can't I? You're structurally subordinated and you loan money with no covenants. Like, what's the big deal?
It's a big surprise.
It's a big surprise to some 32-year-old kid from Wharton, but it's not to me. Like Gazette or something like that type of company? Yeah.
There's some leaps of faith there.
Sorry, I see.
Before we do Brian's question, yeah, you do that.
Federal receivership and whether it works.
The problem that I see with receivership cases, and I've done quite a few of them, is even more so than bankruptcy, your case is as efficient and as effective as your judge lets it be. Done equity receivership cases where the judge says, you tell me what you want and that's what we're gonna do. And right down the hall in Chicago, I had a judge say, show me statutory authority that lets me do that. And he was not impressed with equity receivership should be run like bankruptcy cases. He did not consider that to be authority of any sort or variety. And so the problem is you get a judge and the judge gives you as much rope or as little rope as they happen to give you. And if you get the right judge, it can be very, very effective. And if you get the wrong judge, you're spinning your wheels. There is.
Any other questions? Anything else you guys want to touch on?
Let's talk about melting ice cube.
Oh,
a
yeah,
little bit
by the way,
and
yeah.
Argue the other side of the valuation issue, normal definition of fair market value or reorganization value or fresh start value is you don't value the company taking into consideration the adverse impact of the over leverage and the illiquidity. You value it as if it were restructured and had a normalized, industry comparable capital structure. And so when the parties run a pre-petition auction process, nobody steps up to the plate, and some, distressed debt investor, cuts a deal with management where on the eve of filing, they put together a stalking horse bid that doesn't reflect fair market value. And that's an issue, I think, of concern to junior creditors, junior lien holders and trade creditors. And it's hard in this over leveraged environment to adequately address that because there's a melting ice cube. The company doesn't come into chapter until it's on with this pre-baked half-done auction process until it's out of money and payroll isn't going to be made. So what do you think about that problem?
Well, when I was a young lawyer, a melting ice cube meant perishable collateral. It meant cattle that had to be fed, and if you didn't feed it, it was going to go away. It meant frozen grocery products that were going to be ruined if they weren't disposed of in some orderly fashion very quickly. Melting ice cube has sort of evolved into the going concern business is going to die on the vine. And I've been involved in cases where there truly was an emergency. And if you didn't do something extreme, this business was just gonna die on the vine as you watched it. And I've been involved in even more cases where the melting ice cube is created by the secured creditor refusing to let the company have the cash it needs to keep the ice cube from melting. And so the secured creditor is imposing the furnace that's melting the ice cube. And some judges push back on that, and some judges say, you know, you don't have to agree to lend any money, and I'm not going to force you to lend it. I mean, you're not in a situation where you can compel lending, but there's a fine line there, and I think that secured creditors have come to understand that they can extract an awful lot in return for giving you the money to run a business for a period of time, and that's where you get benchmarks for sales and plans and this and that are all tied to liquidating that collateral as quickly as possible. And it's primarily done under the guise of we're saving the going concern business. But to me, I think many of these cases are self-generated emergencies.
But don't we, to kind of take the other side of that, we all see situations where company goes into Chapter 11, you've got a working capital facility, and you've got a term loan, let's say, not a complicated capital structure. The working capital facility is totally covered. All their exposure is 65% of eligible AR and inventory. And leading up, the reason you're in Chapter 11 is because, you're saying to the oh, come on, ease up on the advance rates, take out one or two of those discretionary availability blocks and hope springs eternal. And the ABL lenders, no, look, I'm not willing to do that. Okay. I'm covered here. I may or may not be covered. I don't want to get any more exposed to, I'm not obligated under the loan document to increase my exposure, and I'm unwilling to. Put it in Chapter 11 and I'll increase my exposure a little bit, and I'll run a going out of business sale because it's Halloween and we might as well just do this during the holidays. And then the term loan lender comes in and people come in and they complain and they say, it's being unreasonable. We don't have enough time. But you got a term loan. If the term loan lender thinks there's value, then the term loan lender can step up and take out the ABL or backstop the ABL facility. And when they do, you get more time. And when they don't, you don't. Like, too bad, so sad.
I would further defend the secured creditor here, as is my role. Why is the secured creditor suddenly in this situation where they're the only ones that are the savior of the business? What has gone so wrong here that the management team or the equity sponsors don't want to put in more money? And especially in the world we're living in with the credit agreements that we've seen the past couple of years, generally it's not we're running out of money in 6 months, let's start a plan to figure out how we can get you repaid. It's we can't make payroll in the next 2 to 3 weeks.
6 hours.
Yeah. And so is that the situation in which, as a private credit lender or a bank, I want to look at this and say, yeah, I'm just going to throw more good money after bad. Just whatever you say, I'm going to put more money in for it. Or do you have to step back a little bit and analyze, is there a reason that we got here that we need to solve as part of a bigger problem? Does this company actually have value? I think part of that could be solved by being able to go to your secured creditors earlier in the process, which is something that I think companies have just stopped doing because they don't need to. And so they don't want to come to the secured lenders. They view them as the bad guys, but by not doing so and then coming to them in the true emergency situation, I think it's really lessened a gap we have between how we could get to a consensual arrangement and something that's not going to be quite so predatory.
Do you think, Lindsay, in a covenant light environment, I guess the company doesn't have to go to the lenders?
That's right.
Because the lenders don't have any control and they only go to the lenders at the 11th hour when they're yeah, I see that. Yeah.
I mean, I see that too, and I think strategically it's a really bad idea. There's certainly two sides to that coin. One of the issues that we talk about is the lenders creating the leverage by withholding the cash, but it's easy to say to a lender, you should advance more money, but then the lender, of course, is taking the entire risk on what the consequence of continuing that operation is. And there's nothing in those loan documents that require them to do that. And frankly, there's nothing in the marketplace that should require them to do that. And so the solution is seldom black and white. If you trusted your lender and if you were comfortable that there would not be adverse consequences when you go to your lender as soon as you start to sense a problem, instead of waiting until you're on fire and your building's about to burn down, that would obviously, I think, in most circumstances, be a much better approach. The problem is, sometimes you go to the lender and the lender understands and works with you to try to do something, and sometimes you go to the lender and the lender freaks out and the lender declares a default, and you now have the emergency that you could have had 5 months later if you had just kept your mouth shut. Maybe, maybe. I mean, it's a very, very much, in my opinion, it's a two-edged sword, and there is no black and white answer that one thing is right and one thing is wrong.
So we're at the end of our time. Any final question or questions?
Didn't catch it. The code for this session was 3MC5.
Oh, yeah, it works. There you go. Tim can hear me now. Tim's not paying attention. Neema can hear me. I learned a lot about Subchapter 5 from Neema.
I would have done it.
Everyone's decided to raise the limit.
Neema, it seems like the role of the trustee is like a kind of almost like a quasi mediator in some circumstances. Would that be a fair characterization on my part?
I've only been involved in one Subchapter 5 case, and it was filed as a two-party dispute just to prevent my client from continuing to terminate a contract. We filed a motion to dismiss, but after the initial, whatever their initial exclusivity period was, then they just dismissed the case voluntarily. And I didn't have Neema to be my Subchapter 5 trustee to push these people along. Yep.
I'm doing this, Aaron. I'm just like sitting back and kicking back and doing this business.
Try to talk really loud too.
Grab 'em. Hello, Neema, by the way. I'm Adrian Welters. We haven't met, but we have now. My name's up there, so you probably assumed I was something because you know these characters.
Oh, these are on. Okay.
Yeah, they're
You do
live.
have to get them really close.
It's a hot mic, people.
Yeah.
There's things we can't talk about.
Oh, that's my fault.
I brought the code with me.
I have one in my bag, but
We can share.
I'm afraid someone would refer to the code that I wasn't familiar with. I'm like, oh no.
I was trying to work out that point about the eligibility question, right? Because we have the
Do you knock out the whole claim? Oh, sorry, that's that.
I looked at the language. Oh yeah, I see why. I see why some people might come up on that, right?
Yeah,
As a bona fide dispute as to liability or amount, right?
yeah, so we have a case and every one of the petitioning creditors has pending litigation. So yeah, they took the position. We didn't dispute their whole. Light is really bright too.
Yeah.
Or are there more people?
There'll be some more because they
did the
split out.
Let's do that.
That might be, we are allegedly at.
Let me help about because all I need you to do,
Yeah, Howard, can you do our?
Yeah. And of course,
Um,
so
don't
I
have
mean,
to
literally,
worry.
like, I'm probably going to click like 3 times, probably, because it's just like, when we're at the, and we might get started. And then we'll be started.
Which one's on?
Sorry, it's 3.
Yeah.
Yeah, it's paraphrased.
That's all right. I'll see you.
No, that is,
Right. Yeah, that's from it. It's the partial and you've got a one-time guy who's secured on the phone.
Right.
So actually, they question was like, does that count for eligibility at all? Check out the security.
This is a hot mic situation.
It is, but like you have to be close to the mic, so. He'll probably know when he's really here too much.
Stomach starts growling.
Yeah, that's right. Never, things happen.
You going to the gym? Yes.
I
How
am.
many people, is it Lower County?
I have no idea. I just responded to Brian Shaw. Yeah, I don't know. I just told Brian. Not my payment to Brian. It's usually pretty well.
Yeah.
How was Ron? You have all.
That was great.
I heard that pretty well. Yeah.
As I said when I started talking, it was roast.
Yeah.
Yeah, a few beers in me. Vince's is pretty funny too. Did I learn to be a good writer because of Ron? No. Did I because of Ron? No.
She'll learn something.
Yeah, Kathy spoke first. She actually stole two of the stories I was going to tell. One of which was that Ron had a tendency of arguing like this, and he'd have his keys, and back in those days, we had something to change. in our pocket.
Oh, and he would
And Jackie DeFini, I remember, make him move everything in his pockets and put it on the podium before he started his argument.
Stop in the middle of arguments.
Wow. He was also Ron, I don't know why. He wore a short sleeve shirt.
Well,
But he was.
one of my first jokes was, I wanted to dress in honor of Ron and wear suspenders, but my wife told me that I got rid of them 25 years ago when they went out of style.
Yeah, I think it was, I feel like it was like one of the early cases I worked on with Alan Rose. When he was,
But he had
about that.
suspenders probably.
Yeah,
He always
well,
wore.
and then, but then Alan Rose kind of like.
Yes.
And Alan probably. I sliced the end of my finger off.
I was gonna ask if there's a story behind that.
It was late at night and I wasn't paying attention. It was like 2 weeks ago, so it's still not, it'll be shorter. And, yeah, there was a lot of blood. All night, yeah. There's nothing they can do. for it. Yeah, it's just, they just had to, I couldn't get it to stop. And it was late at night, so all the urgent cares were shut. So I'm like, I don't know where I can have it. So I wrapped my finger in a napkin, started driving, remember where it was. And I arrived at 10 p.m. and I went home.
I'm about 2 weeks out of the booth.
Oh,
So I
yeah,
saw like two weeks ago.
that's not
I'm
fun.
gonna join you in the fun. The recent crazy.
Mine was just stupid. I'm like, I was not paying attention. You know, you're just like chopping up stuff and thinking about something. Not watching.
Yeah, I roll my
Yeah.
ankle.
Sharp knife,
I guess that's
sharp
why
enough to cut your
people
finger
say
off?
you should be present when you're trying to do something.
Is that the sign-in sheet we signed when they came in?
Can we take a break and get liquor? Like
No,
halfway
no
through
one
our
would-
We
program?
go to when we're done, but no later.
Yeah.
15 minutes is all that's required to get there.
Who's that? There you go.
Like right now. you're going?
It went south in the second half. It was like, you know, half time thinking, garbage and.
We'll remember to repeat what is said if anyone says anything. You can come up and you can pick up a microphone. Yeah. I didn't know you were. Yeah, and it's Friday.
I was just thinking that earlier with it's a new age. It's a new age. Thursday's great because people will come downtown for a Thursday. No, Thursday would be great. You get more people.
Thanks for your work. Thanks for what you do. You do a lot of shit for me. A lot of shit. And that's what it is too. Thankless work.
Brian, you're the best. But next time wear a tie. Yeah. So were our mics.
That was my fault. Howard cleaned it, so I cleaned it. I'd like to know.
Ryan, are you talking?
Okay, we're going to get going with our last panel as people start trickling in. A couple of reminders for people in the room. There is a CLE sign-in sheet on the same table where you got your name tags. If you have not done so, you only need to do it once. Please find your name and put your signature by your name. That will serve as the record for the college to maintain for you to get your CLE credit, and they will subsequently be sending emails to everybody who attended and giving you instructions on how to get that. So if you have not done so, it doesn't matter when you sign it. You can sign it after you get a beer at 5:30. Just please sign it so you get credit. And with that, I'm going to turn it over to our ethics panel moderator, Adrian Walters.
Thank you, Brian. It's my job to get us to the beer in time, right?
Yep. We needed a Brit for that.
Right. Okay. So welcome all to this final panel. We'll be looking at ethics of involuntary bankruptcy. I'm delighted to be joined by three very distinguished luminaries from the far side, as I look at it: Howard Edelman from Edelman and Gettelman, David Neff from Perkins Coie, and last but by no means least, Nancy Peterman from Greenberg Traurig. So folks, our topic's involuntary bankruptcies, and it occurred to me, like, why are we talking about involuntary bankruptcies? So can I ask each of you, are you experiencing more involuntary cases in practice now compared to, say, 5 or 10 years ago? And if so, why do you think this is? Perhaps, Howard, I can ask you to start on that.
Well, thank you. Why to file an involuntary bankruptcy? And why is there an increase in involuntary bankruptcies? A couple of theories and then one sort of point. A lot of unemployed lawyers. So there's a lot of bankruptcies being filed now by people that aren't familiar with bankruptcy. Secondly, creditors are becoming more aggressive. They're doing things that they didn't do 5 and 10 years ago from time to time. But I think the number one reason for involuntary bankruptcies is for venue control. And it's sort of a resource we don't think about very often, but it's been becoming more and more common for creditors to organize before a company goes into bankruptcy, because they're either not being paid, they rumor mill, they're in a trade association. So if you look back over the last 10 or 15 years on involuntaries that were successful in venue control, it's something that creditors should think about more, because creditors generally know when something is coming, and they can have much more involvement if they can pick a venue where creditors actually have some influence. So, for example, years ago, many of you remember this, in the Handy Andy, used to be a hardware store chain in Chicago, in the Midwest, called Handy Andy. And in that case, there was a bank group of 10 banks, and the debtor, for whatever reason, told the bank group that it was going to file a bankruptcy in Delaware, back when going to Delaware was becoming more and more common. Well, the bank group, the next day, filed an involuntary in Chicago, which kept the venue in Chicago. Now, while the debtor's lawyer did that, don't know, but there's an example of one clear example where an involuntary has made a difference. Secondly, in central grocers, a case still pending here, fortunately, the creditors had a prescient group who filed an involuntary in Chicago first, and then Central Grocers filed in Delaware. Well, you probably know that Rule 1014 makes the first to file judge decide all venue issues. So in Central Grocers, when we tried to move the case from Delaware to Chicago, we were able to do it before Judge Hollis rather than the judge in Delaware. And she moved it to Chicago. So the involuntary there provided a real forum for keeping cases in the Seventh Circuit. So to this group, I encourage you to think about involuntaries, the ethics of involuntaries as venue choice. So keep in mind Bankruptcy Rule 1014, and when you get into thinking about involuntaries, keep in mind venue. So we see the venue as something that is a very good way to keep the cases in the Seventh Circuit. Now, that's a jealous view from us that want cases, but it's a clear way to start the process. So we see more of that coming as creditors go on. Adrian?
Nancy?
Sure. So I guess I think of involuntary somewhat fondly, only because they help. An involuntary case is the reason I got my first job. So one of the first cases I worked on was Envirodyne Industries, which was supposed to be a Delaware bankruptcy filing. An involuntary was filed by the bondholders, and the case ended up here in Chicago. And ultimately, there wasn't even a fight. Like, the debtor decided to stay here. My firm was debtor's counsel, and that was my first experience in Chapter 11. Today, I don't think of them as so fondly because I have dealt now with 3 or 4 over the past 2 years of involuntaries, mostly filed by non-bankruptcy lawyers. And we're going to talk a little bit about maybe some diligence you do before you file the involuntary. So I think that involuntaries have become a little more prevalent because non-bankruptcy lawyers don't quite understand the implications of the filing. I also have heard from creditors. I spend a lot of time in the healthcare space. In the healthcare space, there's a lot of receiverships that get filed, and creditors tend to file involuntaries in some of those situations, and their reasoning is transparency. So if you have some creditors are not comfortable dealing with receiverships, they're not comfortable dealing with assignees and assignments for the benefit of creditors, and so they view the involuntary in Chapter 7 filing as at least giving them visibility as to whether or not there's anything out there that should be chased.
I will pick up on that diligence point about sort of not non-bankruptcy lawyers getting involved in this and what you actually need to do in terms of diligencing the process when we get to our scenarios shortly. David, what about your experience?
So when I was a young bankruptcy lawyer at Jenner and Block, my late great partner, Larry Wolfson, put the fear of God in me about all the horrible things that could happen if I initiated an involuntary bankruptcy case. So I get violently
we're gonna talk
gilly
about some of those.
thinking about this subject.
Well, we'll have you talk a little bit more about the possible parade of horribles momentarily, David. But in terms of what we're going to be doing during the panel, we have some scenarios that raise a range of legal, practical, and ethical issues that coming up in connection with involuntary cases. And so we're going to look at those in some depth. Before we do that, I'm going to ask the panel to provide us with a quick refresher on basic law and practice under Section 303 of the code and how these things tee up, what the requirements are, what you need to prove, and so on. Firstly, Howard, I think it's fair to say that an involuntary is not really the sort of thing that most seasoned bankruptcy professionals, possibly for David's reasons, really handle very much, and they're actually something of a different beast from a litigation perspective. Is that a fair assessment?
Well, yeah, Nancy's going to talk about the qualifications to be petitioning creditors, and I'm going to talk a little bit of just briefly about the parallels between an involuntary and an adversary proceeding.
Right, that's what I was getting at.
Oh, do you want me to start with
that'd be
okay,
easier.
sure. So the basic requirements for filing an involuntary, for those who may not know, are, generally you need 3 creditors to sign the petition. In the aggregate, those claims today should total roughly 18,000, or should total at least $18,600. That number changes every so many years. I don't remember how often, but it gets adjusted upward periodically.
Every three.
Every three. Thank you for the professor here who knows all those details. If a company has fewer than 12 creditors, only one petitioning creditor is required to sign the petition. Like David, I learned as a young lawyer that it is almost impossible for a company to have fewer than 12 creditors. So you better be absolutely 1,000% sure on that, because by the time you add up utility companies and things like that, they usually have more than 12. So generally think you got to have three creditors with claims totaling at least 18,600. Those claims cannot be contingent and they cannot be disputed in dollar amount or for purposes of liability. In addition, for the case to survive, the alleged debtor, once the petition's filed, has to generally must be generally not paying its debts as they come due unless the debts are disputed. So that all sounds really simple. And we'll talk about this a little more in the scenarios, but there's a lot of questions over what is a disputed claim. If part of the creditor's claim is disputed, but not all of it, are they a valid petitioning creditor? Because you just reduced the claim, let's say from $10,000 to $5,000. Do you knock out that whole claim? There's a case, a circuit split on that. And then there's a lot of questions about what it means to generally not pay your debts as they come due. So if you're paying maybe 50% of your debts, are you generally not paying them as they come due? And then that's also tested on the petition date. So I had one case involuntary this past year filed against one of my clients. They were generally paying their debts as they came due when the petition was filed. But if that petition had been dismissed and then refiled about a week later, they would not have been generally paying their debts as they came due because they would have completed an asset sale and there would have been a whole host of creditors not paid. And then I'm just going to throw out a few other points and then I'll turn it to Howard for the details on the process. If a creditor signing the petition is a corporation, they need a lawyer representing them. And this has come up now multiple times over the past 2 years with petitions with a random corporate entity signing a petition with no counsel. In addition, it surprises me that some people don't know you cannot file an involuntary against a nonprofit. So make sure you read the statute and don't file an involuntary against a nonprofit entity. And then finally, a situation that came up for me this year, which I did not know that bankruptcy rule 1003A existed, but that rule exists. And so you cannot acquire claims for the sole purpose of commencing an involuntary petition. And so how that came up for me in a case, and we ultimately settled it and the involuntary was dismissed, is that, the creditor was supposed to file an affidavit. And in the affidavit, they were supposed to say that they did acquire the claim. These were the terms of the claim purchase. They did not acquire it, they said, for purposes of commencing the petition. However, what happened factually is that claim was acquired actually by a lawyer. And then the lawyer used social media, Twitter, Facebook, et cetera, to solicit other creditors to file an involuntary petition against my client. So we, raised all sorts of issues with that. And as us bankruptcy lawyers do, we settled that issue.
Adrian, may I pose a question to you as a professor? What is the basis for the Rules Committee to promulgate a rule, 1003, that says you can't acquire a claim for an involuntary, where nothing in the code says you can't acquire a claim for an involuntary?
Don't know.
Professor Baird?
Oh, Judge Cox.
Okay, I'm just going to pick up a little bit on some of the basics so that it gives you context. And you probably know most of this, but like every petition in bankruptcy, an involuntary petition has got to be verified. There's got to be corporate disclosures, and there's got to be service, just like a petition in federal court. In the area of contesting an involuntary, Judge Cox wrote a decision in the last year that suggested a receiver has standing to move to dismiss an involuntary, but a receiver doesn't have an ability to contest an involuntary. And that's one of the more recent cases. I think that's 318 Retail is the name of that case. But that's one of the few decisions written recently by our circuit. Everybody knows that defenses are raised by Rule 12, and the Bankruptcy Rule 1018 makes the adversary rules apply to an involuntary petition. So in short, an involuntary petition turns into an adversary proceeding. Discovery rules apply. Debtors are challenging the good faith nature of the claims, whether they're subject to a bona fide dispute, whether legitimate creditors, all those come through the motion practice. And then there is probably a little known section of the code, that 28 USC 1411B, that says an involuntary is tried without a jury. So there's no jury trial right, apparently, in an involuntary case. Pretty straightforward preponderance of the evidence standard. And the most important thing that I try to emphasize when I represent a debtor is to try to get a prompt hearing. I think Rule 1011 or 1013 requires the court to determine involuntaries at the earliest practical time. And that's obviously to protect the value of the company. So in short, there are 10 or so rules that apply to involuntaries that you must read and consider before you file. And in essence, it really turns into a contested proceeding, and the judge will ultimately decide. Adrian?
And if it's contested and it gets dismissed, David, and we get into 303I and where you started, what can possibly go wrong?
So let's talk about the misery that awaits should you be involved in one of these beasts, and why Larry Wolfson cautioned me about filing such a case. Even responding to such a case may not necessarily be a picnic for you either. But Section 303I deals with dismissal, and I'm going to recite it. It's not very long. If the court dismisses an involuntary petition other than on the consent of all petitioners and the debtor, and if the debtor does not waive its right to judgment under this section, the court may grant judgment, permissive, against petitioners and in favor of the debtor for costs or reasonable attorney's fees, or against any petitioner that filed a petition in bad faith for approximately caused damages or punitive damages. So this is serious stuff. There is a presumption that where an involuntary is dismissed and where the debtor does not otherwise consent to it or waive its right to collect attorney's fees, there's a presumption that the debtor is entitled to his attorney's fees.
David, does that presumption arise from the cases? Because I don't see it in the code.
Yes, in the cases.
Right.
Most courts apply that presumption. Now, the courts will look at the relative culpability of the parties. They might say, well, these two petitioners really were just along for the ride. There was really, as is often the case, there's really one party that's driving the involuntary filing, and the court can apportion the fees. There is some case law, it's a minority view, that allows relief under 303I against agents or principals of petitioners, because the statute itself speaks just of petitioners, but there are several instances where courts have gone beyond that. And of course, we as lawyers are bound by Rule 11, 9011, and we can be sanctioned under that particular section of the code. Now, for those who are defending against an involuntary, it's very important to get paid, and not to basically rely upon the fact that should ultimately you fail in your endeavors and the court enter an order for relief, that lucky for you, you'll have a gap claim, because the cases that I've seen hold that no, you don't have a gap claim, because gap claims are for what is incurred in the ordinary course during the gap period, and litigating unsuccessfully against an involuntary is not considered to be in the ordinary course. So you have a journalistic claim.
Can it be a substantial contribution claim?
I think we think of that from a creditor's perspective as opposed to a debtor, and I question how much contribution there would be if you actually lost in seeking to go against an involuntary. Two instructive cases I wanted to bring to your attention. They're both in the materials because they exemplify how serious the litigation is around filing an involuntary. The one is the John Richards Homes building case from the Sixth Circuit in 2006. In that case, the petitioner entered into a contract with to buy some property and to have the other party construct a home on it. Things went south. The petitioner sued for breach of contract and hired a PR firm to publicize his lawsuit against the builder and that the builder was not good on meeting his debts. He filed the bankruptcy petition as a sole petitioner, even though he knew that the debtor had more than 12 creditors. The bankruptcy court awarded $4.1 million as compensatory damages, $2 million as punitive damages, and over $300,000 of attorney's fees. That was affirmed on appeal, both the district court and the Sixth Circuit. And then In re Rosenberg is a case at the 11th Circuit from 2015. This case went on for 7 years, culminating in a jury trial on bad faith. And ultimately, of course, the motion to dismiss the case was granted, and the debtor was awarded over $1.1 million in compensatory damages and attorney's fees of over $1 million. So it's not for the faint of heart to get involved in an involuntary. Not to say that there isn't its proper use, but there are a lot of ethical issues that filing these cases raise.
Which we can get into very shortly. Just quickly, David, would it be a fair summary to say then that the attorney risk comes through Rule 11 and not directly through 303I, though I guess, of course, there could be malpractice implications.
There are a
if
few
you.
cases, that's Rick's got his hand up. There are a few cases that have found attorneys liable, but in one case, the attorney agreed contractually to be liable for any damages that should be awarded. So, but I think you're right. It's really Rule 11.
Rick.
They did, yeah. You raise an interesting question, and what the state of the litigation is that you have as the creditor. You know, are you already involved in a lawsuit? How do you raise it now? Do you add another count to it and say, oh, I just got dinged for these damages? I've not seen that type of a situation arise. So I would think you could certainly make that argument. The question is whether if you're a creditor and you have you get dinged for damages when your involuntary gets dismissed, can you set off those damages? And Rick Mason says you absolutely can. And
And he has no microphone to dispute that, yes.
There you go.
yeah, I think Jay Geller is shocked by the state of the law in the Sixth Circuit, which allows a secured creditor to partially waive his security to become a petitioning creditor.
That seems like a really good strategy, but yeah.
That was the law under the act
Yes.
as well. It's been around.
Any other questions, people? I thought not.
So let's turn to our scenarios, which raise a multitude of issues that we can get into. So the first one, we have manager and majority owner of LLC who calls for 10% member to pay their share of the operating deficit, even though the operating agreement only requires a 10% member to fund losses of a project currently in progress when the project ends. Manager then instructs counsel to solicit creditors to join manager in filing an involuntary. Counsel goes ahead, but doesn't disclose that manager's claim is unmatured and likely subject to a bona fide dispute. So, Nancy, first things first, can a ringleader with a disputed claim tee up the involuntary and get other people in who might be eligible, I guess? Do you think?
I would say yes. I think that if there's a valid reason, for an involuntary to potentially be filed, that some creditor with a disputed claim can have, either they can make phone calls or their counsel could make phone calls and talk to other creditors. If I were the lawyer, I probably would not call a creditor and say, hey, I want you to sign an involuntary petition. I might say, hey, I have a client, they're doing business with so-and-so, and we're just trying to understand the state of play with respect to that business. Are you having problems collecting debts? What's going on with your claims against that company? I think that any lawyer who might be making those calls, especially as time goes by, if there's multiple conversations or conversations with maybe 3 or 4 creditors, make it extremely clear who your client is. Like your client will be, what do we call them in this? Whoever the main antagonizer in this scenario is, they're the ones that you represent, and you need to make that clear to the other creditors. And then ultimately, if a petition's filed, you're, as the lawyer for that particular creditor, you're not going to be having your client join in the petition.
Yeah, 'cause I was going to say, you're not going to join in. So if you think about obligations to the solicited creditors, your point is you need to be full and frank in terms of disclosure.
Yeah, I think you do. I mean, I had a case this past year with 3 petitioning creditors. Two out of the 3 had pending lawsuits that were, had been pending for a couple of years. My client was disputing the actual claims being asserted in those lawsuits. The 3rd creditor had a valid claim. They were one of those corporations that signed the petition, and they didn't have counsel. They thought their counsel was counsel to one of the other petitioning creditors. And so that created some issues amongst the creditor group. And then after that, we began every call with the creditor for the other 2, or the counsel for the other 2 petitioning creditors, explaining they only represented 2 out of the 3 petitioning creditors. This 3rd creditor was a corporation who signed the petition without counsel. But I do think you have to be very clear, as we do in many situations, very clear in your engagement letters, very clear in communications and discussions, who's your client, and make it clear to those who you don't represent that you're not their lawyer. If they have questions, they're going to need to go get their own counsel.
I have a real question under these facts, whether this is a bad faith filing. Because this is really a partnership dispute, and the one partner is using the involuntary to further those purposes. And I think there's a case in the materials, I think the Global Energies case, not terribly dissimilar. So Nancy, I hope you didn't file this case.
I did not. This is not a real world situation, but I still think that as long as that disputed creditor is not signing the petition, that should be, this is not a valid, I read it and I thought this is not a valid claim. You've got a 10%, you're looking for this 10% equity owner to put in what really is not a required contribution. It's a discretionary contribution at this point in time. So it's not a valid claim for purposes of the involuntary, but there might be other valid claims out there that, and if those creditors want to pursue an involuntary, they would.
Howard, anything to add?
Well, I tend to disagree with Nancy on this. I think a ringleader in an involuntary not only has to disclose, but I think they have to have a business purpose. And if their real motive is to get around the dispute and to try to get the defendant in a bankruptcy by soliciting other creditors, I think that has a taint to it of bad faith, because they can't do it for themselves. They're soliciting others to do it. And clearly they would have an obligation to disclose the disputed claim that they hold or that their client holds. But I think there's something to be careful about here, because The problem with involuntary bankruptcies is they're always determined in hindsight. Your motive is going to be painted on the wall after you go to trial. So you have to be doubly careful about how it comes out. So I would recommend people being very cautious about being a ringleader when your claim itself cannot be a petitioning creditor. There's no law on this. We've looked for some cases. This is coming up a little more and more, where again, either there's too many lawyers or aggressive lawyers, but I think you got to be real careful about what your real motive is.
Yeah, I do think that.
I see a professor
Oh.
hand in the back.
Go ahead.
Bruce. Say it again, Bruce. Would it be barratry or champatry, says Professor Markell.
I will defer to David or Howard on that.
Yeah, I, in an involuntary context, I don't see that. But again, when you've got a disputed claim, might be a little more applicable.
I do think that there's a potential claim against the disputed creditor, right? For whether it's, I don't know, tortious interference with the business or something like that. I do think even if you have a valid involuntary that ultimately files, the company ends up in bankruptcy. If the debtor learned about these facts, as Howard said, the debtor could potentially sue that particular creditor.
That I think is what Professor Markell is getting at. David, then Rick.
Yeah. Yeah, I don't think that, like for this particular, I think that conversation would not be, let's say, well advised. It's not a very valid threat to start with, right? Because you can't, this issue over the 10% member contribution is not a claim that would be able to initiate an involuntary. So I mean, I would hope that there would have been discussions between, I'll tell you, when I read this, usually how this would work out under an LLC agreement is that under the LLC agreement, if there's, let's say, discretionary contributions to be made into the LLC, in certain circumstances, the other members can make that contribution and simply dilute the equity interest of that particular member. But I do agree that like you should not be going to the 10% LLC member and saying, I'm going to file an involuntary, so pay me. First of all, not very persuasive because you have no right to file an involuntary.
Dave, just to find a point on that, it seems to me that the motive to begin with is what you measure for good faith. So if somebody is trying to create an involuntary when they don't have a basis to do it themselves, and they're doing it for a punitive nature, really to get back at the minority member, there's where the bad faith comes in. They're using the involuntary. I think when you use the involuntary process to have a private motive, if you will, you run into problems. You run into more difficulty in bad faith.
Yeah, I still think it's a claim that the debtor would have against them. I don't know why a judge looking at the involuntary would be measuring the bad faith of some non-petitioning creditor. But that's not to say that this is a good idea. We shouldn't leave you with that impression.
Right. Rick.
It's skirting the lines, the ethics rules, let's say. Right.
It's coming.
Yeah, and I think I guess I'll repeat that. I just remembered that. So I'm going to try to repeat that in very short form here. So this particular scenario, unless I missed something in it, never says that the counsel to the person who's angry at their 10% member represents anybody other than the party who's angry. And so I made the assumption that there could be 3 other creditors out there contacted. They could get other counsel who could then maybe file the petition for them. The point that was just made by Rick in the audience is that if we change that set of facts, and let's say the lawyer of the ringleader starts calling people and saying, great, we're going to file an involuntary now. I'm going to represent all of you. Let's say there's 5 creditors, and keep secret the fact that his client has a disputed claim. Like you cannot do that. Like if you are representing jointly multiple creditors, multiple parties in a case, you have to disclose all of that information to each of them. You can't keep that secret from the others.
I'd like to emphasize something that Rick Mason just pointed out on pre-filing due diligence. And involuntary lawyers often focus on the claim itself and not about the preferences. And I've seen several cases at least, where the petitioning creditors funded the payroll tax liability for the principal because they filed an involuntary, were sued for preferences, paid the preferences, and then the fella got off the payroll tax, the priority claim. So that is an area to be careful about, due diligence.
And we'll have more to say about due diligence shortly. Shall we have a look at David's scenario? So in this one, we have Bluefin, a note holder in a group of lenders whose notes are secured by mortgage on a resort hotel in the Caribbean, wants to borrow in bankruptcy so that borrower could use Section 365 to ditch its brand affiliation. The controlling note holder, however, just wants to pursue a foreclosure outside of bankruptcy. And Bluefin loans the borrower 300 grand to cover the borrower's attorney's fees for the bankruptcy case, which also gives Bluefin an unsecured claim. It then gets 2 other creditors to join in the filing of an involuntary petition. Now, David, does lending money to fund the case, thereby giving rise to the unsecured claim on which the lender could petition, raise any issues?
Yeah, so if I could just flush this one out a little bit.
Of course.
So this is a real case that I was involved in, involving a very fancy resort in a Caribbean island. And the controlling note holder wanted to get rid of the brand affiliation. And the administrative agent for the bondholders didn't really think that was such a good idea. And ultimately, they had an event where there was a reappraisal, and this controlling note holder was no longer the controlling note holder, but still wanted to get rid of the brand because thought that would realize tens of millions of dollars of value would be unlocked if the brand was gone, and devised a strategy to basically come to me as the owner's lawyer and say, I still want to do this. And my position was my client just doesn't care. The property's being foreclosed on. We've already made our money. The property needs money put into it for capital expenditures. We're not doing it. You know, if you want to file an involuntary, knock yourself out. And of course, they no longer could do it because they didn't control the bondholder class. So they said, well, what if we loan you, the debtor, $300,000 and it can be used to pay your retainer? And I said, knock yourself out if that's what you'd like to do. I mean, if you want to file the involuntary, you go ahead and do that. And that's exactly what they did. They found 2 other creditors from the Caribbean island, and they used the $300,000 they had loaned the debtor, which the debtor used to pay attorney's fees, to initiate the case. So I didn't see anything wrong taking the $300,000. I mean, I had no problem doing that. It was obviously fully disclosed, fully vetted before Judge Shannon in Delaware when the case came up. Not on a motion to dismiss, because remember, I was a debtor. I didn't care. Imagine a bankruptcy case, an involuntary, where the debtor's completely agnostic as to whether the involuntary existed or bankruptcy existed. the lender, with now a different controlling note holder, filed a motion to abstain in favor of the foreclosure proceeding that was going on in Caribbean Islands. So, so I didn't see any issue with me, as long as there was full disclosure of it, if that's what they wanted to do. You know,
You took their money.
I took their money and basically said, here it is. There's issues with it. It will be vetted in the case. Well, how did I spend? I'm going to tell you how I spent the money. Jay Geller asked how I spent the money. I will tell you how I spent the money. This case had literally had 6 or 8 depositions and the exchange of 10,000 pages of documents, all in the space of about a week.
Wow.
And no one complained. None of the lawyers complained. It was really a beautiful thing. No one asked for continuance of the hearing. Everyone just sucked it up and did it and went to trial. I sat in on the depositions. That's exactly right. But then I sat in at the trial and the Judge Shannon would look at me and I'm like, whatever.
So what
I
happened?
literally took no position on the motion.
Did anyone challenge the bluefin claim or?
Yeah, oh yeah, and
Okay.
they made a
Yeah.
huge deal over the fact that this is how they acquired a claim. And then ultimately, it was revealed that maybe they were less than truthful in how they got to the other creditors to join them. And ultimately, Judge Shannon granted the motion to abstain to allow the proceeding to continue in the Caribbean. But the issue did come up about sanctions, because think about all the money that was spent by the lender in challenging this recalcitrant note holder. But it wasn't going to be under 303I because I was the debtor. It was going to be the lender, and ultimately they just dropped it.
And so just a twist on that, we had a scenario this past year where an involuntary was filed against, it was a hotel that our client was the owner of. We similarly didn't care, right? We were like, lender foreclose against it, creditor who's filed the involuntary go for it, but there was a bad boy guarantee in place and a poorly worded one. And so we ended up having to walk a very fine line of filing something that was kind of like an opposition to the involuntary, carefully worded to try to not trip the bad boy guarantee. So, they're kind of strange situations that come up in those single asset cases, essentially.
This was, in my opinion, I would never have done what that lawyer did. I thought that was much too aggressive a strategy and also an improper purpose in the use of Chapter 11. But I stuffed the bill in my shirt.
Shall we have a look at another one? Which gets us on to particularly into issues of diligence, which Rick was mentioning a few moments ago. So in this one, we have a debtor, Bob, who's defaulted on an unsecured loan from Ursula. He has a partial defense of usury to the interest component because we're in a jurisdiction that has an interest rate cap. Ursula retains counsel, identifies 2 other creditors of Bob, one Marty, who claims to be owed $3,000 on a promissory note, but has not supplied any documentary proof, and the other, Steve, who's apparently owed $7,500 secured on a sailboat. So, starting with Howard, is it unethical to file an involuntary on behalf of a creditor despite knowing that the creditor's claim is subject to a defense?
So, and scenario 3 is really intended to illustrate the need for due diligence by the lawyer. Here you have first a promissory note reference, but the lawyer doesn't get the promissory note. And then a second petitioning creditor orally consents to joining and then disappears. And the petitioning creditor, the attorney files the case anyway. So it brings up the question of how far and what is best practices for a petitioning creditor's lawyer to document, if you will, the claims that are going to be the petitioning creditor's claims. In our example here, the lawyer did very little, and it seems to me is going to suffer the consequences. the law is a bit unclear on whether a petitioning creditor can have partially a disputed claim or the entire claim is tainted by a dispute as to some amount. Some is uncontested, some is contested. Is that a legitimate petitioning creditor? There's cases all over the map, in our materials, we cited some of them, but there's no good circuit authority yet on that issue, the partial secured claim. But on the secured, unsecured portion, as Jay Geller pointed out, there's clear authority for a secured creditor to reduce their collateral to become an unsecured creditor and be a petitioning creditor. So that's fairly well established now. And that was the same as under the Act, I believe. Here, the lawyer went ahead with an involuntary, really based on oral representations of the creditors. And to say the least, no lawyer should rely on an oral representation when the client tells them they have a promissory note. Well, where's the note? Where's the grid? How much has been paid? What is, there's no due diligence that's here. So the takeaway here is due diligence. Get the documents, follow the line, follow the path to the claims, determine the effort, and be ready for the contest. Again, I think what we're seeing is there are more involuntaries filed, and the cases that are coming out are almost all extreme cases. A few, Judge Goldberg wrote one in 2014 where it was clearly, it's in our materials, utilizing as a collection tool. And again, I think a little knowledge is dangerous to lawyers that know about involuntaries but don't know the detail of it. But the takeaway on this scenario is you can't act on oral representations. You've got to act on due diligence.
So David and Nancy, just quickly, if I can interject for a moment, I was thinking about this this 12,500 claim that goes down to 10,000 principal because there is a partial defense, right? So kind of what's the point? Because if this was claims allowance, right, you'd just go, it's a $10,000 claim, and you would allow it, and you disallow the portion that is subject to the defense, right? So what's the point under 303 that makes some courts say that there would be an eligibility issue for the entire 12,500?
I don't get it. I don't understand it. But
Bruce
we
does.
have someone who
Is
used
it
to be a judge who
it
will tell us.
is it a subject of a bona fide dispute as to liability or amount? Is that it? Is that?
Yes.
Right, because as right, so because essentially because the language of the code comes out as being if there's a contest as to amount, right, that causes the problem. Judge Carr. So could you just
Sure, exactly.
right? So Judge Carr suggests you just release the 2,500 interest component, and then you've got an undisputed claim as to principal for the entire amount of your remaining claim.
Yeah, but this is a good defense though to involuntary petitions, because one of the involuntaries I dealt with, that was part of our motion to dismiss. In addition to the fact that our client was paying its debts as they came due, we also noted that 2 out of the 3 petitioning creditors, 2 of them had pending lawsuits against the company. We had counterclaims against them. Probably one of them was close to the magnitude of only a small portion of dispute, but we nonetheless use that to ultimately leverage, a resolution in true bankruptcy form to get the case dismissed.
But the other problem here, right, in filing, in going ahead and filing this one, to Howard's point about diligence, is, you're struggling to get to 18,600, right? I mean, like, even if we release the 2,500 and follow Judge Carr's suggestion, that gives us 10. We've got Marty who's gone missing with his 3, but the other guy, well, as far as we know, again, subject to diligence, appears to be fully secured on the boat, right? So doesn't that knock out the 7,500? Am I wrong?
So, yeah.
So not a good idea to file this case then. I think we're agreed. Shall we move on? Here's the fourth one. And given where we're at in time, this will probably be the last one. So we have in this one a distressed corporation that in a last-ditch effort to save itself discontinues an unprofitable product line, and in so doing ends relationships with a bunch of component suppliers. But one unhappy supplier wants to pursue an involuntary and instructs counsels to solicit other suppliers who've received partial payments from the corporation to join in with the petition, even though bankruptcy would expose those other suppliers to preference avoidance action. So this brings us back again to what Rick was saying a little bit earlier. So, question panel, is it unethical for counsel here to solicit creditors where an involuntary may not be in their interest because it will trigger potential avoidance exposure? What about that? Nancy?
Sure, I'll jump in. So as with all of these scenarios, I'm going to say they are like right on the edge of the ethics rule. So here, again, I read the scenario as saying that the lawyer who's out there, the soliciting counsel, is soliciting for frenemy. So I think that counsel can contact other creditors, but the point raised by Rick is ultimately if those other creditors become the soliciting counsel's clients, then yeah, you have to do the diligence and you better be advising them if they have preference exposure. It's not a good outcome for one of your clients to file an involuntary and then have to pay back a significant sum of money. But if all you do is represent frenemy and that's it, you can certainly go out and solicit the creditors.
Right, particularly if the other creditors are represented by counsel, they're that stupid that they're not looking at, involuntary 101, which is, well, what preferences have you gotten? Then that's on them.
Yeah, and I think that was kind of one of the issues is what's the duty of the soliciting counsel? Do they need to tell the other petitioning creditors to get their own counsel?
Right.
And so I think if soliciting counsel is not going to represent those other creditors, then they should be at least informing those creditors that, look, I'm not your counsel. You need to go hire your own counsel and have your counsel do the diligence with respect to your claim to make sure you have a valid claim for purposes of filing the petition and otherwise aren't exposing yourself. So I think you do want to encourage them to go get their own counsel.
But if you recommend separate representation for those creditors, doesn't that harm your own client's prospects of filing the involuntary? And is that a problem?
I think you have to tell the other creditor that they have to go get their own counsel, that you can't represent them. You can't dig into the details with them about their claim. If you're not going to represent them, you can't dig into the details about whether or not they have preference exposure. But I think you do have to tell them. I mean, just like we tell our clients, if they're going to engage us, you need to go talk to other counsel to review the engagement letter. I think that you would have to tell them, I can't represent you, but please, consult with your own lawyer.
Disclose, disclose, disclose.
Because it is uncomfortable especially if you know. I'm assuming here soliciting counsel might not know those details.
So we have, I think, a few more minutes.
Howard has.
Howard, sorry, go ahead.
I think the area that's on that we want to address today is what happens when you try to settle an involuntary.
That's exactly what I was gonna come on to.
And this gets pretty interesting because it comes up a fair amount, and it's a thorny little problem. But I want to pose a scenario. Involuntary file, debtor does not file an appearance. Creditors go to the debtor, debtor goes to the creditors, they make a deal, and nobody appears for the debtor. No one appears. And there's a first status hearing under the summons, as you know, involuntary summons sets a status hearing. Nobody appears. So you don't have a debtor that appears, you don't have petitioning creditors that appear. And what does the court typically do in that situation? They dismiss the case without notice to creditors. So the way you get around the notice requirement on making a settlement in an involuntary is nobody appears. And now it's dismissed for want of prosecution. So what's wrong with that? Rick Mason, you're shaking your head.
That's English law, that is.
So this state of the law is that you judge the petitioners on the date the petition is filed. So if the debtor goes and pays one of them off afterward, they still count as a petitioner. Now, if you buy off all three of them and notice then goes out and no one else wants to join in the petition, that's where I think you end up with the result that Howard.
Yeah, I think it's a really hard, I'm just gonna say a hard question. So I actually asked this question of the other panelists because I don't know what the answer is. So a couple ways that we've dealt with dismissal, and one was at the judge's instruction. I won't say, but a judge here in Chicago was you send out a notice to all the creditors and say the petition's being dismissed based upon a settlement. But he didn't believe that we needed to disclose the details of that settlement. If someone had a question, they would come to court and oppose it. And in another case, we had discussions with the petitioning creditors, but they had a bad petition. So we had a pretty good case for sanctions. And so we agreed to allow for dismissal of the petition, and then we all took 90 days to see if we could reach agreement. So
Bob,
Judge Furay.
Judge.
So, yeah. Right.
It's honored
I
in the
don't
brief.
know.
So what should the judge do when no one shows up? Bob. Bob Lawless says duty of candor to the tribunal, says Bob Lawless.
I'm sorry, I couldn't hear you.
Yeah.
The petitioning creditor's attorney. Conflicting with the duty to your client not to show up, so it gets dismissed.
Disclose.
Yes. Yeah, I think dismissal is really hard with when there's a settlement. I'm not sure how you best handle that.
I think the problem is it's honored in the breach. It's called in court. Nobody shows up. The tendency is clear my docket, dismiss the case. It's all done. So there's a little gap in how you protect that system from that, but why shouldn't you issue a rule on the petitioning creditor's lawyer to disclose the settlement and file a list of creditors? Well, but that's the point though. if the disappearing creditors, but once you file and you've appeared, you can't just walk away. You've got to report to the court. If you can't just say, I'm not going to show up, that's what
People don't show up for motions all the time. Motion denied.
Judge Carr, 1 minute.
But you won't know who to send the notice to.
I
in
think
these
there's a good
cases, that's the
argument,
problem.
no.
Yeah,
I think
so
there's a good
would say
argument
no.
if all three of them are happy.
How do you know who to notice?
Exactly. The debtor's not showing up either.
And how do you
You're
protect the
not?
right to
Yeah, I
join,
don't
says Judge Carr?
I
don't know.
I don't know. I
And
don't,
you'd have to require the petitioning creditors to send out some sort of notice.
yeah, to the
And the debtor
creditor.
to
they know.
reveal the creditor list of.
Yeah, if you can find the debtor. The
Yeah,
debtor, I think the debtor is obligated to file a list, and generally, I think they do not. That's true. You could do a publication notice.
Well, there you are. I learned a ton. I learned an awful lot. I learned that involuntaries are way, way easier in England and Wales. But it's 5:30. Thank you very much to the panel. And here's Melissa.
Hello, going to close things out for us this evening. First of all, I would like to thank Brian and Debbie, our education committee, and all of our speakers. They were great. And Brian read out all the names to you earlier, but thanks again to all of our sponsors. It's really amazing that we can have a program like this that is available free to students, to the rest of the public, and we can only do that because of our sponsors. And many times our sponsors are so generous that we can actually give money to our foundation from anything that's left over, which is also a really great cause. So thank you again to all of our sponsors who make this possible. A couple of administrative matters that Brian wants me to make sure I cover. The panel 4 CLE code is 5EB4. And remember, if you want CLE or CPE, you need to sign the sheet out in the lobby before you have all of your drinks and appetizers. I will make a couple of quick comments about the college. And by the way, for those of you who don't know me, I'm Melissa Kibler. I'm with Accordion, and I have the privilege of serving as the chair of the college for this and next year. We have a lot of exciting things happening at the college. This is an example of one of them on the education front. We worked tremendously hard during the pandemic to continue what we have done in terms of education and the other value that we as an organization provide. But of course, the education in that setting wasn't able to be as robust as it is when we're all sitting here together talking and debating the finer points of law and practice. So it's very exciting that many of the circuits are holding a wide variety of programs, whether it's an entire day of ethics styled as a game show that the 5th and the 10th Circuit did in Utah earlier this year, or it's an author talking about life experiences that the 4th Circuit is doing. I believe it's tomorrow night. So there are really a wide variety, not tomorrow, but next week, but a wide variety of programs that are going on, different formats. Many are available to the public and certainly to other fellows in other circuits. So please check that out. Those are all listed on the college's website. We have a couple of new committees this year. We had a one-year process where we closely studied the issues of diversity, equity, and inclusion and how they affected us as an organization and how they affected the industry. And we had a esteemed commission headed by 2 judges that came out with a report that was issued in April of this year. And we've implemented many recommendations of that group that are far beyond the scope of what I'll talk to you about today. But one thing, of course, that we did was establish a permanent committee on diversity, equity, and inclusion within the college. And that committee is extremely busy and really accomplishing a great deal right now. Also, we have actually as a result of that commission's report, there was a new committee formed called the Freshman Fellows Committee that was initially envisioned as something that would be more focused on diverse fellows, and realized that all of our fellows need a lot more hand-holding and information to really learn about the college and become active, productive members of the college. So that group had its inaugural program yesterday, and we're very excited about what that holds for us as an organization in terms of being even more effective in accomplishing our mission. So those are a few highlights. For those of you who are fellows, we will look forward to seeing you, I hope, in Orlando in October, in about a month, for our meeting that is at NCBJ. And for all of the rest of you, thank you so much for joining us today. And we look forward to networking with you at the drinks and appetizers outside. Thank you.
Howard? A pleasure. Nancy, great. I want to make sure I didn't crush your finger there.